Good morning. Good morning, my friends, and thank you so much for coming to hang out with me this Friday, September 6th of 2024. There's a lot of wackiness going on YouTube, so I hope you guys can find me. I can't even find myself on YouTube right now. It says that this show was posted 11 hours ago and has no views. Like I cannot even pull it up on my phone as being live right now. So is YouTube acting wonky for anybody else, or is it just me? Like, I can't even pull up the chat on my phone, on my own channel. So bizarre. Well, I hope you're here. Can you hear me? Your app is being crazy too? Hi, Maureen. Thanks for finding me. Like, legit, I'm looking at my phone. It says this show right here was posted 12 hours ago and it has 60 views, but we're live right now. So, what is the deal? People actually got a notification. YouTube's been acting up. Last night when I did the show with Mark Betterill, my camera was inverted. I still can't figure it out. I have to mirror my camera so that when I'm looking at myself, if I go like this, it's on the correct side. It's a mess. We're gonna try and do it. We're gonna try and do it today. Scott, I'm sure you will let me know. Good morning. Scott's one of my amazing moderators. You'll let me know, Scott, if it starts getting crazy. Says it started a minute ago, right? But I can't pull it up on my phone. Like it's just not. I don't know. Sometimes technology just doesn't want to cooperate. Sometimes it's StreamYard, sometimes it's YouTube, but we're here for it. So many of you have asked me to cover this case. Thank you, On Top, for being on top of the super sticker, as always, with your kindness and generosity. So many of you have asked me to cover this case about Carly Gregg out of Mississippi. And once I took a look at it, I get it. Now I understand why. There hasn't been a huge amount of interest, it seems, in this case. So while Court TV started covering it a little while ago with some of the hearings, they don't have a ton of views. It's not, it's no Sarah Boone. And I don't understand why, because to me, Sarah Boone is a case where there's legit video of her taunting her boyfriend in a suitcase. There's no question that she knew he was in that suitcase. And I don't see why there's so much public interest in a case like that, when a case like this to me is so much more interesting. But that's just me. And I'm here for it. And I'm here to talk to you about it because what I find so disturbing about this case and so many other cases that we're seeing lately is young teenagers, 13, 14, committing murders. I don't know I am sure that we can all agree that there is a severe mental health crisis among our young teens that is not being addressed properly. I don't know if we're just hearing more about it or if it's more prevalent. And this girl, Carly Gregg, is 14 years, she's just turned 15. When she was 14, and this murder just happened in March of 2024. So this case is going to trial within 6 months. It's crazy. It's scheduled to start on September 16th. On March 19th of 2024, Carly Gregg, who was 14 years old, lives in Rankin County, Mississippi, shot and killed her 40-year-old mother, Ashley Smiley, who was a math teacher at Carly's school. After she shot and killed her mother, she called her friend to come over and see the dead body. She texted her stepfather from her mother's phone and said, "When are you coming home?" And then she lay in wait for her stepfather to get there. His name is Heath Smiley. And she shot him in the neck. He was not killed, thankfully, but he called 911. She ran away. She was apprehended about a half a mile from home. There's some video showing some things that she did, including, singing with her dog while she was waiting for her friend to come over or waiting for her stepfather to come home. And we're going to talk about it. We're going to look at some original news clips. And I love to go to local media. for my coverage and to shout out local reporters who have done an excellent job, including independent media, Jackson Jambalaya, who has covered this case at length. I've been corresponding with he or she, and I've put their website or their YouTube channel. I've linked it below because they've covered a lot of these pretrial hearings, including the preliminary hearing, which I wanted to play for you today, but the audio on it isn't great. And I know that it's hard when we can't modulate the audio. And so I'm really loud. The audio is really soft, but instead we're going to talk about what Jackson Jambalaya reported on with regard to what happened at that preliminary hearing. And then it's linked below. So if you want to go watch the entire hearing yourself, you can. Some news coverage on the case, some hearings on the case, the hearing to keep out the media and to reduce the bond. And then there was a plea deal that was offered to Carly about a week ago that was rejected. We're going to take a look at that as well. She's been held in Rankin County Jail, I believe, since her arrest. And because of her age, there is a detention hearing held every 30 days in Mississippi. We're going to take a look. We're going to look at the judge. His name is Dewey Arthur. If I could read my notes in the dark over here. Dewey Arthur, Judge Dewey Arthur out of Rankin County, Mississippi. The friend did go over there. Tara. Was driven over there by her dad. Went in the house. This is going to be a fascinating trial. She's being tried as an adult. And so she's facing not the death penalty, although Mississippi does have the death penalty, but because of her age, even though she's being tried as an adult, she's facing 2 life sentences. And the Canton Leaf Blower Society has just started their meeting outside my window. There's probably about 40 of them out there. So we'll do the best we can here. Hopefully you can't hear it. Fairy Raven, this is what I've been saying all along. Thank you, Fairy Raven. Hello to Ireland. I think the kids affected by being homeschooled during the 2020 the global panty are showing more signs of mental health problems. Yes. She would have been 10 during that time, a middle schooler. And as the mother of 3 girls who were in middle school during that time, I can tell you how devastating it was. Them being out of school for almost 2 full years, them being not able to socialize with their friends, them being isolated and pretty much dumped by their school district to pretty much learn things on their own. It was devastating, horrific. And during that year, yours truly went on a school board meeting, Zoom call, and really kind of let them have it about mental health, about how this is going to be a mental health crisis for our children. What are you doing about it? I was muted during that meeting, and mysteriously the video was lost of the parent comments during that meeting. So I've been very vocal about this issue since the beginning because I could see the writing on the wall. I was fortunate enough to be home with my kids and to be able to try and help them with this online schooling, which was just a joke, basically. And at some point, I called the school and I said, listen, my kids are on strike. I'm not crossing this picket line. So you need to tell me what needs to happen to make sure that they pass for the year because the school district abandoned them. And this is New York. I mean, we're talking about a very, very high property tax area. I know in other parts of the country it was better, but here it was a mess. And some children were good at remote learning and some were not. And I think what's happening now, I'm guessing we're seeing after effects of that. We saw this recent horrific school shooting in Georgia by another 14-year-old who, according to all accounts, was screaming out for help for years. Jess says, I live in Mississippi. Our school's closed for 2 months, end of 2020 year. Our kids were back in school for 2021. Yeah. But there was so much, I don't know, devastation because of that. So I don't know, Jess, if you're saying that it really didn't affect you guys in Mississippi, but trying to get any kind of mental health assistance for your children still to this day is virtually impossible to find someone who's covered by insurance that you don't have to pay $200 an hour to. And we're failing our children in so many ways. And I'm horrified by it and I'm devastated by it. And, The children are our future, right? Wasn't there a song about that? Laura Riker, my daughter suffered during the big C, ADHD and distance learning did not work together. The schools were struggling. Yeah. Yep. JP Eagle says, I agree that kids suffered during COVID, but also parents in general being too busy working and other things and not looking after their kids. I think the latter is as much of an issue. That may be. Not everyone is fortunate enough to have a dual income family. I mean, a single income 2-parent family where one of the parents is able to stay home with the kids. It's just not possible in a lot of situations anymore. And parents have to do what they have to do to put food on the table. So I can't fault parents as much as I need to, I don't know, fault the system. Something more needs to be done for our children. If you see something, say something. So yeah, California was locked down on an overkill level. Yep. I know so many people who took their kids out of school in California and put them in private school. So yes, we can't use the whole word team, Brittany. Thank you so much. And the reason that I'm able to cover these tough topics that YouTube doesn't like me to talk about, because they will deem them unfriendly to advertisers and strike the whole stream. But I care enough about these topics that I need to talk about them. The reason that I'm able to talk about them is because I have a sponsor for this channel. So before we get into the coverage on Carly Gregg, I need to play a word from my sponsor. If you haven't heard about the major hack that has happened recently, you should be aware of it because your social security number and every other American's social security number has been leaked to the dark web. But luckily, my sponsor can help you with that. So let's hear a quick word from my sponsor of today's show, Aura. Today's video is sponsored by Aura. And it's a really important time to be talking about them because hackers may have stolen the social security numbers of every American. Over 2.9 billion records were stolen from National Public Data, which offers personal information to employers, private investigators, staffing agencies, and others doing background checks. These stolen records include a person's full name, address, date of birth, social security number, and phone number, along with alternate names and birth date. And members of this hacker group have reportedly released this information on the dark web for free. I don't know if you've ever had your identity stolen, but I've had clients who've had their identity stolen. And not only is it a major hassle, but oftentimes before you find out, it's too late. The damage can take years to undo, and it's a hassle that you definitely do not want to deal with. So if you haven't been taking precautions before with your personal information online, this should be a huge wake-up call. You've never been more vulnerable online than you are right now. But I'm not too worried about it because I use Aura. Aura alerts me if they find my phone number, my email, my social security number, or any other personal information on the dark web. They're going to let me know fast if anyone tries to use this information to access my credit or bank accounts. They give me up to $5 million in identity theft insurance should the worst case scenario happen. They also provide a bunch of other features to keep you safe online, all inside one app. And you can go to my link at www.aura.com/Melanie Little to try it for free for 14 days. That'll be enough time for Aura to find out if any of your personal information or data has been exposed. I highly recommend you do this right now because not only is National Public Data not going to do anything to help you, they probably aren't even going to face any repercussions for this breach. I'm not leaving myself and my family vulnerable to data breaches. And if you don't want to either, you want to go to my link, www.aura.com/Melanie Little, to try 2 weeks for free. You can thank me later. Oops, you can thank me later. I had to prevent the leaf blowers from being heard on camera. Yeah, it is sad, Brinley, that major issues that need to be talked about cannot be fully discussed because I have to eggshell my way around them, tiptoe over the eggshells. And then what happens is YouTube will shadow ban the video. They'll deem it not friendly to advertisers because we're talking about subjects that they deem unfriendly to advertisers, and that's why it's great that I have a sponsor. So check Aura out. They can help protect you. I don't know if you've ever had your identity stolen or know someone who has, but it is a mess that you don't want to have to deal with. It's a nightmare. It can take years to undo the damage. Your credit can be trashed for 8 to 10 years, and it's a nightmare. So check it out. Let's go to some of the original coverage on the Carly Gregg case, the original arrest. This is from a local station out of Jackson, Mississippi, WAPT News. And this was the day after the shooting. The shooting was on March 19th. And this piece is from March 20th. Let's take a listen.
When we arrived here earlier, the police presence was pretty heavy, but if you take a look behind me, it has cleared up a lot since then. We talked to some residents in the area. They say that this area is typically safe, but tonight it turned deadly. A teenager is now in custody after pulling out a gun on her parents, according to Rankin County deputies.
When we got here, we were able to determine that the juvenile used a firearm against her parents. One of them is deceased and one got transported to the hospital.
Chief Investigator Fred Lovett said the deadly domestic incident unfolded around 5 p.m. in the Farmington Station neighborhood. Deputies say the stepfather said his stepdaughter opened fire on him after shooting and killing her mother, his wife. The Rankin County coroner identified the teen's mother as 40-year-old Ashley Smiley. The stepfather was shot in the shoulder. The sheriff said the teen then ran to the backyard and jumped over a fence and fled.
Juvenile fled the scene and we were able to find her and take her to JDC.
Rankin County police say they had to search for the teen through the neighborhood using a helicopter from the Mississippi Highway Patrol. The teen's stepfather was taken to the hospital. Lovett says they are investigating to figure out the motivation behind the shooting. The Rankin County Sheriff's Office said that they are not sure of the stepfather's condition in the hospital at this time. Brooklyn Journal reporting from Rankin County, 16 WAPT News.
Shout out to Brooklyn Joyner. Excellent local reporter. Seems very young and good for her. I see a long and storied career ahead of her. That was WAPT News. Mississippi. Let me see. Jackson, Mississippi. Yeah, that was pretty much it for that piece. The next piece is from
in Rankin County,
this is from another local station out of Jackson, Mississippi. This is WJTV News.
In Rankin County, a 14-year-old girl is being charged as an adult after investigators say she killed her mother and injured her stepfather. The teenager's name is Carly Madison Gregg. Sheriff Brian Bailey says his office got a call about a shooting about 5 o'clock yesterday afternoon on Ashton Way. That's between Old Fannin Road and Hugh Ward Boulevard out in the reservoir area. When deputies arrived, they found the girl's stepfather with a gunshot wound to the shoulder. And the stepfather then told deputies when he got home, he found his wife dead. She has been identified as 40-year-old school teacher Ashley Smiley. The teen appeared in court today. She pleaded not guilty, and her bond has been set at $1 million. Officials with the Rankin County School District said Smiley was a teacher at Northwest Rankin School. They say Gregg was also a student at the high school. The city of Flowood released a statement about Smiley's death on social media, saying, quote, "Our deepest prayers and condolences are with our Northwest Rankin family during this difficult time. We love our Cougar family, and you are not alone," end quote.
More breaking news. The teenage girl accused.
Thank you, Melly. Thanks for Melly made it. That's what I'm wondering, too. I'm wondering this, too. Was something else going on in this home, Elle? This is what I'm wondering. This is my question. I mean, I'm sure certain people are born evil, but does a 14-year-old girl one day just wake up and decide to kill her mother? I need to know what else was going on. Apparently there's going to now be an insanity plea in this case. They're trying to blame their issues about medication that she may have been on, Lexapro, and that perhaps they had adjusted her medication within weeks of the killing. So much more to this case than meets the eye, and I'm here for it with you. Let's hear this next piece. This is from WLBT, another local station out of Mississippi.
More breaking news. The teenage girl accused of killing her mother and injuring her stepfather in Rankin County is being charged as an adult.
Yeah, she went before a judge today. Authorities say 14-year-old Carly Madison Gregg. This young lady is charged with murder and attempted murder after that shooting on Ashton Way we brought as breaking news to you last night. Here in your sides, Chris Fields joins us live from outside the court to tell you exactly what happened in court today. Chris?
So Howard and Courtney Ann, Carly Gregg went before a Rankin County judge today where she pled not guilty to shooting and killing her mother and also not guilty to attempting to shoot her stepfather. Now, during that hearing, she was granted $1 million bond. Now, those in the neighborhood say there are more questions than answers. A sigh of disbelief.
I hate to hear that all this happening.
As neighbors recount those frightening sights from Tuesday evening.
Everybody on this street, go ahead and lock your doors and stay inside. Someone who is dangerous is on foot.
Deputies said that someone was 14-year-old Carly Madison Gregg, someone who they had lived by for years.
Just really sad about everything that happened yesterday, and it was just really surprising. And my prayers are for the family.
Tuesday, around 5 p.m. on Ashton Way in Rankin County, authorities say Carly Gregg shot and killed her mother, 40-year-old Ashley Smiley, a teacher at Northwest Rankin High School. But she didn't stop there. Deputies say the teen then shot her stepfather with a pistol. Authorities arrived and found the stepfather was shot in the shoulder. Neighbors like Lauren Martinez say it's fairly a quiet neighborhood and close-knit community. After the shooting, Gregg ran away and was captured not far from the house.
Scary. And the main thing is just, I keep saying it, but it's unexpected because this street is filled with families and kids that just come all play together. And it's a very quiet, very family-oriented community. So it's something, would be the last thing that you would ever see over here.
Other neighbors say these types of incidents are very unfortunate.
Things happen everywhere. It's definitely not an ideal situation. And I absolutely hate that it involved a child. Hopefully, I'm sending up prayers to the family and everybody around that was involved.
Now, Sheriff Brian Bailey says Gregg will be charged as an adult in this case. She has since been transferred to the Rankin County Adult Detention Center. Reporting live from Rankin County, I'm Chris Fields. 3 on your side.
Good morning, Bulldog Mom. Good morning. Good morning. Good morning, Laren. Good morning, Laren D. Thanks you guys for the super chats. Yeah, there's a lot of discussion about this in the chat, and I see you guys debating it. And right, are we to blame medication? I don't really think so. I think that medication, when taken properly, even in low doses for young teenagers, can be helpful. We can't say there's a mental health crisis and then blame the medications, right? Big pharma, mental illness. Was there something else going on? Where did she get the gun? I think it was her mother's gun. I think she got it from her mother's room. So let's take a look at some of the pleadings. We like to do that too. As you know, we are a document-based legal channel. So we can look at the original indictment. Let's take a look at that first. This is the original indictment that was filed on May 22nd of 2024. So she was detained until they had a grand jury hear her case. And this is when the indictment came down about 2 months later. This is a super fast case to go to trial. The fact that this case is going to trial within 6 months of the crime is, can you remember last time we covered a case or anyone covered a case that went to trial within 6 months? It's crazy, but they're moving this thing right along in Mississippi. So I guess they don't They don't play in Mississippi. This judge doesn't play either. We're going to watch a little bit of him. Here's the indictment that was filed on May 22nd of 2024. This is the state of Mississippi versus Carly Madison Gregg. It's an indictment for the offense of first-degree murder, count 1, count 2, attempted murder, and count 3, tampering with physical evidence. State of Mississippi, County of Rankin, in the Circuit Court of Rankin County, January term 2024, recalled May 22nd of 2024. So that is the term of the grand jury. They were originally called in January. Sometimes grand jurors serve for up to a year in some states. Sometimes they can, and they hear lots and lots of cases. I know lots of you have sat on grand juries in New York and other places, and you've told me about your experiences. The grand jurors for the state of Mississippi, taken from the body of good and lawful citizens of Rankin County, elected, summoned, impaneled, sworn, and charged to inquire in and for the body of the county aforesaid, at the term aforesaid of the court aforesaid, in the name and by the authority of the state of Mississippi, upon their oaths, present that count 1, Carly Madison Gregg, on or about the 19th day of March, 2024, in the county aforesaid and within the jurisdiction of this court, did willfully, unlawfully, and feloniously, with the deliberate design to effect death, kill, and murder Ashley Smiley. Again, as I told you, that's her mom, a human being in violation of Section 97-3-191A, Mississippi Code annotated of 1972 as amended, constituting a related series of acts or transactions or a common scheme or plan. And that count 2, Carly Madison Gregg, on or about the 19th day of March, 2024, in the county aforesaid and within the jurisdiction of this court, did willfully, unlawfully, and feloniously attempt to kill Heath Smiley, that's her stepdad, just lost my place, a human being, and acted with the deliberate design to effect the death of Heath Smiley, but failed to successfully complete the act in violation of sections 97-1-7-2 and section 97-3-191A, Mississippi Code annotated of 1972 as amended, constituting a related series of acts or transactions or a common scheme or plan. Count 3. Carly Madison Gregg, on or about the 19th day of March, 2024, in the county aforesaid and within the jurisdiction of this court, believing that an official proceeding was pending or might be instituted, and acting without legal right or authority, she did willfully, unlawfully, and feloniously intentionally destroy, mutilate, conceal, remove, or alter physical evidence with intent to impair its use, verify, or availability. Oh, I'm sorry, verity. I think it's small font. Alter physical evidence with the intent to impair its use, verity, or availability in the pending criminal investigation or prospective official proceeding, to wit, she removed a security camera and concealed its location, constituting a related series of acts or transactions or a common scheme or plan. And all the above being against the peace and dignity of the state of Mississippi. And this is the true bill signed by the foreperson of the grand jury, the assistant district attorney. They would say in court, God save the Commonwealth of Massachusetts. This is against the peace and dignity of the state of Mississippi. Interesting verbiage there. And this was signed and sworn by the grand jury foreperson, May 22nd of 2024. Omanra says, usually don't believe in diminished responsibility, but she has a child's brain and is on drugs. 14 years old. 14 years old. Imagine she's in 9th grade. They said she skipped 4th grade and she was very, very intelligent. She had a score of something like 30 on the ACT at the age of 13. She's been held ever since. And I'm going to tell you a little bit about what happened at the original preliminary hearing. as reported by independent journalist Jackson Jambalaya. I'm going to try and play that. Tell me if you can, if the sound is bad, we're not going to do it. And I'm just going to summarize it for you. But I mean, it is interesting. So let's see if we can make do with the sound. And the problem is also there's no closed captions. So all right, it may not be doable, but let's give it a shot, eh?
Audience too, as it relates to a preliminary hearing. Most of our experience with courtrooms is on TV, and we understand from our TV watching that, they talk about beyond a reasonable doubt. That's the standard, the burden of proof in a criminal trial. That's not what this is today. This is a preliminary hearing. What a preliminary hearing is it reasonable, one, to believe that a crime has been committed? And two, is it reasonable to believe that the defendant committed the crime? That's it. So while beyond reasonable doubt is up here, the standard for probable cause is down here.
I love how this judge explains to everyone watching what exactly they are doing and what exactly a preliminary hearing is. And he's explaining more so than teaching the law like Judge Cannoni did in Massachusetts, but he's explaining, and he's a firm believer of media being allowed in the courtroom. He is not going to exclude them. You're going to hear some testimony during this preliminary hearing from the investigator, which is shocking. People are saying the sound is good, so let's play it. And let's keep going with this.
So just make sure we all understand that as we go through this process. All right, so I mentioned that Mr. Investigator Cotton has been sworn as on the stand. Mr. Berry, you can go ahead.
Thank you, Honor. Now, before I proceed, I know this is a preliminary / bond hearing, so the state will probably list a few more facts that are for probable cause just to before we make full determination as well.
Fair enough.
Okay. State your name for the record.
This is Zachary Cotton.
And where are you?
Rankin County Sheriff's
And what's your
investigator.
Were you working on March 19, 2024?
Yes, sir.
Did you get a call about a shooting on that day?
Yes, sir.
Could you tell the judge about what the call was about?
Our dispatcher received a call. The person on the phone was frantic. The exact details were not clear, but it was something to the fact that their child had shot at them and shot them in the neck. Deputies responded to the scene, were met with a male at the door, and found a deceased female inside one of the bedrooms.
Okay, this is Zachary Cotton. He's the lead investigator who responded to the scene. So again, if you're just tuning in, welcome. This is a preliminary hearing. It was held on April 16th of 2024 regarding the murder of Ashley Smiley, age 40, of Rankin County, Mississippi, by her daughter, 14-year-old Carly Gregg, on March 19th of 2024. Carly Gregg is set to stand trial next week, starting on September 16th. And so we are doing a deep dive into the early proceedings in this case, considering that it's going to trial within 6 months. She's being tried as an adult. And so we're going to hear what this investigator, Zachary Cotton, came upon that day when he responded to the home in Rankin County, Mississippi. Moving on.
Anything his officers observed about that?
He was upset. He had been shot in the shoulder, and he had said that his stepdaughter was the one that had a firearm, that he had gotten the firearm away from her.
And was at that time, did he identify the shooter?
Yes.
What's the person's name of the shooter?
Carly Gregg.
Are you familiar with Carly Gregg?
Yes, sir.
She had courtroom today.
Yes, sir.
Can you report her out to the court?
He's sitting over there.
Was Miss Gregg on the scene at that time?
No, sir, not at the residence.
Okay. What was the next thing that happened?
Deputies were attempting, and law enforcement in general were trying to observe the area to see if they could locate the suspect, Carly. She was later found approximately half a mile down the road and taken into custody.
Was the murder weapon and attempted murder weapon recovered?
Yes, sir.
What was the male's name? Just for,
Heath Smiley.
was he taken to the hospital?
Yes, sir.
Was the statement eventually taken from him?
Yes, sir.
And did it match the 6 that you just told before?
Yes, sir.
All right. Let's talk about, was there any surveillance of this video cameras in this incident?
Yes, sir.
All right. Tell us what would you observe generally from this surveillance?
There's a exterior camera. It's in the garage. Shows the Carly and her mother Ashley arrive home. There's another camera that's located in the kitchen. The kitchen camera shows that after they walk into the residence, that at some point Ashley goes into Carly's bedroom. Carly goes outside with the dogs. Eventually, Carly comes back in after Ashley's taken some items out of Carly's room. Carly walks back in, notices her mother is in the bedroom, and then proceeds to walk in the direction where Ashley and Heath's bedroom is. You see her come back into view of the camera. She has her hands concealed behind her back, out of view of the camera. She looks into the kitchen and then proceeds to walk into her bedroom, and then you hear a gunshot, a scream, followed by 2 more gunshots. Carly proceeds to return to the kitchen, concealing her hands behind her back. You hear a heavy object being set down on the counter, and then she proceeds to get Ashley's phone and begins texting on it.
Do you know who she was texting?
I believe it was Heath, based off of the text messages that he received.
In the text message, did it appear that she was impersonating her dead mother?
Yes,
And what was the substance of those texts?
essentially asking about how long it would be till he got home.
On the video, is anybody else besides Mr. Heath and the defendant present? Is anybody else there?
But it was just Carly and Ashley there during that time.
Ashley?
Yes, the deceased.
Okay. Did the video show the defendant running away?
Yes, it shows when Heath comes up, the interior camera had been taken down by the time Heath comes home.
Who showed that? Who would have put that down?
Carly. Then Heath comes in, you hear some gunshots, and then you see Carly run off.
Did anybody else run off with it?
Yes,
Who's that?
one of her friends.
All right. How did the friend get up there?
She was driven over there by her father.
Why was she driven?
Okay, so listen up. This is when she had called her friend over to come see her mother's dead body.
Carly asked her to come over.
Do we know for what purpose?
She showed her deceased mother to the friend.
You showed her deceased mother.
Yes,
Do you know why she asked her over there?
not entirely sure. She just said it's an emergency. I need you to come over.
What is the time difference between the killing of his mother and shooting the shot?
Approximately 45 to 50 minutes.
Were you able to recover? We talked about these cameras. Where were the cameras found?
There was the one that was in the garage that was attached to the garage door opener, the device itself where like the light is found and all that. And the other one was later found in the fridge of the residence.
And what is the deceased full name?
So she took the security camera down and hid it in the refrigerator.
Ashley Smiley.
And did you talk to someone named Brooke in association with this?
Yes.
Tell the court about the conversation with Brooke.
She essentially stated that she was invited over to the residence by Carly, was unsure what for. That she had walked in. Carly asked her if she had ever seen a dead body before. She said no. Proceeded to show her deceased mother that was in the bedroom. Showed the gun that she used to shoot her mom. Told Brooke that she had 3 shots for her mom, and then she's got 3 more for her stepdad, 2 to the head, 1 to the chest.
Goes to premeditation.
Between those 45 minutes, and this is, I think, for purposes of time you're doing. What was Carly doing on camera? If anything might seem like
Aside from going back and getting the phone and begin texting, she appears to be singing to her dogs. Not really quite sure. The audio is not really clear about what she's doing, and not long after that, the camera.
Did it appear she was aware of those cameras?
Yes, sir, because she had her hands concealed behind her back the entire time, in which she was believed to have a firearm.
Court's indulged. No further questions, Simon.
All right, Mr. Stoddard, Mr. Cole, which one?
Good morning.
About what time did Ashley and her daughter arrive home?
It was approximately 10 to 15 minutes before the shooting occurred.
And do you know what time the shooting occurred?
It was at approximately 4:14 in the afternoon that day.
And what time did Brooke get to the Smiley residence?
Approximately 4:50.
4:50. And how would you corroborate the timing that Brooke arrived at the residence?
Based off of the text messages between her and Carly, and she had texted her saying that I have arrived here at your house. I'm outside.
And when you arrived at the crime scene, were there any other video cameras at the house?
Not to our knowledge, just the one that was in the garage, and then there was a doorbell one that had been ripped off the wall.
And where was the doorbell camera?
It was inside the residence, to my knowledge.
And did you take that into evidence?
No, because it didn't have an external SD card. After speaking with Mr. Smiley, he said that there was no footage that could be pulled off of it.
Did you fingerprint it?
No, sir. No, ma'am, sorry.
And when did you first speak to Brooke?
Later that evening,
Would you
the date that it occurred, the 19th. Yes, ma'am.
When did you first learn that there was a second person in the home?
When we met with her at the sheriff's office.
Yeah, I'm going to object to this line of question. I realize we got into this on direct for purposes of bond, but that's just for purposes of bond. I'm not sure how much this goes to, unless this is for argument as to bond. I'm not sure it goes to probable cause.
I'm gonna let you go a little bit beside that. I don't need a whole lot of this.
I'm sorry.
I'm going to let you go, he says, instead of I'll let you have it or I'll let him have it. Different judge, different rules. Every courtroom's different, my friends.
Sorry, can you repeat the question?
Yes, and when did you first meet Brooke?
It was approximately 8 or 9 o'clock that night. I'm not sure the exact hour.
Of the March 19th?
Yes, ma'am.
And how did you learn that there was a second person in the home?
She had come to the sheriff's office with her father.
And were you aware of this? What if these statements did Mr. Smiley make to you about Carly's state of mind at the time of the shooting?
I did not speak with him directly. I know an investigator went with him to the hospital, but he was extremely distraught, and it was hard to get anything out of him due to the circumstances. The only thing that we really have is what he told the initial deputies about how he had been shot, and then his stepdaughter was the one that had done it.
Hadn't you met with Mr. Smiley since he was released from the hospital?
Yes, ma'am.
And did you have any conversations with him at that time?
Yes, ma'am.
And at that time, what did he tell you regarding his stepdaughter's state of mind at the time of the shooting?
When he said when he walked in, he was met with a gunshot, and that he wrestled over the firearm, and that Carly had fallen backwards, and that her eyes were really big, and he said it looked like she had seen a demon or something to that effect, and she was screaming and ran off.
Did Mr. Smiley
Looked like she had seen a demon or something and ran off. How often have we heard something like this? Like, I just want to play that back a second.
He was met with a gunshot, and that he wrestled over the firearm, and that Carly had fallen backwards, and that her eyes were really big, and he said it looked like she had seen a demon or something to that effect, and she was screaming and ran off.
Did Mr. Smiley also make statements to you regarding Carly didn't seem to recognize him?
It's something that he said he believed that at the time that he thought that maybe she had thought that there was someone trying to break into the house, something to that effect.
Yeah, and this is reminiscent to me, Toy Thomas. Toy, I think you said you live like a block away from where this happened, which is Crazy. And also, this reminds me of the way that Ashley Benefield described Doug Benefield at her trial, that his eyes were huge and they turned black. We're hearing this too often lately.
Did he also make a statement that Carly did not see him at the right time?
Something to that effect, that she had seen a demon.
Also, isn't there a recording of the incident between, where you can hear from the video camera in the garage, Carly and Keith's confrontation in the house?
Yes, ma'am, some of it, yes.
And how would you describe Carly in that video recording?
You can just hear screams, you can't see anything. So I was not sure who the screams were, if they were Heath or Carly, but there was screams. He asked Carly what's going on, something to that effect, and then that's the end of the audio. So you see her run off.
Does he also make a statement in that audio recording where he announces, Carly, it's me?
I believe so, yes.
So would that seem to imply to you that you did not believe?
Your Honor,
her?
object, I may be cautious speculation as well. Object is a speculation.
And to your knowledge, what medication was Carly taking at the time of this incident?
Your Honor, object as to relevance.
You're not close to our argument for long.
Okay.
At the initial date that this occurred, there was no knowledge of her taking medication at the time that she was arrested. It was later found out that she had been on some prescription medication.
And do you know what prescription medication that was?
Not all of it, I believe she had been taking Lexapro.
And do you know how long she'd been taking that script for?
It was, to my understanding, she had changed it at the end of the week beforehand, but not sure the exact date.
The end of the week before the incident?
Yes, in the prior week, yes, ma'am.
So somewhere around Thursday, Friday before
Yes, ma'am.
the incident happened that Tuesday?
Yes.
Is that accurate?
Yes, ma'am.
No, if you're just tuning in, hi, Elf. Hello, Elf. If you're just tuning in, the trial is slated to start on September 16th. And so we're doing a pre-trial. We're doing a trial prep. This was the original pre-trial preliminary hearing that was on April 16th of 2024. The murder was on March 19th of 2024. And this is a record speed trial that is supposedly going, starting September 16th. There's a hearing also next week that we're going to cover regarding whether this should be transferred to juvenile court. And that will be held next, if I can get my calendar open here, that is supposed to be on the 10th, which is Tuesday. So we'll cover that live as well. But so many people have not heard of this case that I wanted to go back and do our usual pretrial prep so that we can get up to speed on what has happened thus far in this case.
And is it also true that when Carly was found half a mile down the road from the scene of the crime, she actually turned herself over to law enforcement?
Well, they stalled her and stopped and asked if she was the girl that was involved in the incident up the road, and she said yes.
Had she flagged law enforcement down?
Not to my knowledge, I believe they just spotted her.
And how long were the investigators, how long was the crime scene inspected and secured before you turned it
Your Honor,
over?
again, object as to relevance. I'm not sure if this has to do with probable cause or bond.
What is the role, Mr. Sergeant?
Your Honor, it just goes to all of the bond that Carly's home has been discharged.
You heard Thomas what?
Her home is no longer the crime scene under investigation.
Mr. Perry?
I think we could just ask, is there about the crime scene? I don't think it has to get into the time.
I'm just stating, objection, asking you a question.
Are you still investigating the crime scene, or has that been turned back over?
At the residence,
Yes.
it's been turned back over.
And she's crazy. What else did Brooke tell you in her statement?
As far as what, essentially that she had gone over to the house, that she didn't know what she was going there for, that she had showed off her dead mother and then asked her to go outside, and she was about to, that he was about to be home.
When did Brooke leave the residence?
At the same time that Carly did.
So Brooke was there at the time of the second shooting?
She was in the backyard.
Wow. So her friend was there in the backyard when Carly shot her stepfather. there's conflicting reports. They're saying in the shoulder. There are some documents that say he was shot in the neck. So I guess if he's testifying he was shot in the shoulder, maybe it was between the shoulder and the neck, and that's why there's some confusion. But I did not know the friend was in the backyard when she shot her stepfather.
And you said that there was a recording that showed Carly singing to her dogs after she had apparently shot the mother.
Yes, ma'am.
Who else have you talked to in regards to this investigation?
All right, again, I object as to relevance as probable cause.
Sustained.
And what, if anything else, was Carly seen doing in the video footage between the 45 to 50 minutes it took between the first shooting and for her stepfather to arrive home?
She comes into view in the kitchen, gets the phone, starts texting what we believe is Mr. Smiley, then walks back into her room, and then she walks back in and appears to let the dogs out and the camera gets unplugged. So it was just.
Look at the other prisoners that are still sitting in the courtroom watching this whole hearing for a 14-year-old girl being charged with murder and attempted murder.
Just a few minutes prior, there wasn't a whole entire duration of the interior camera. It shut off a few minutes after the shooting occurred.
And where was the mother's body found?
In Carly's room.
And how many gunshot wounds had she sustained?
3.
3. And where were those gunshot wounds?
She had 2 inside of the face and 1 underneath the chin.
And were you able to recover the bullets?
Yes, ma'am, 2 of them. Bullet projectiles.
And how many bullets were you able to recover from the crime scene overall?
From the crime scene, there was some fragments that were shot at Mr. Smiley that were recovered. And then there was none of the one from Miss from Ashley that was recovered. The other 2 were recovered during all those.
But all 3 bullets that were fired at Ashley actually made contact with her.
Yes.
And how would you describe the bedroom in which Ashley was found?
Object again as to relevance, Your Honor, as to probable cause or to bond.
What is relevance?
Your Honor, we're just going into
Your Honor,
part of their investigation and questions as to whether or not what's being described is in line with information from other witnesses.
Well, this is not a discovery opportunity. This is a preliminary hearing and a bond hearing. So I'm going to sustain the objection.
This is in Mississippi, if you're just joining.
And do you suspect anyone else at this time had any involvement in the shooting?
No, ma'am.
The friend was not charged. Somebody asked if the friend was charged.
No further questions, Your Honor.
Mr. Barry, you redirect.
just one follow-up based on her cross-examination. What, if anything, did the defendant tell, I believe it was Jordan at the jail?
When she was provided with her paperwork to shut her bond, she made a statement to the effect of, "Oh, you can kill somebody and pay a lot of money and get out of jail."
No further questions.
Oh, you can kill somebody and pay a lot of money and get out of jail, is what she said to one of the, I believe he said the jail employees. That's not a great admission after the fact. That statement will come in as a statement against interest. It's an exception to the hearsay rule. So let's just rewind that a sec.
Jordan at the jail.
When she was provided with her paperwork to shed her bond, she made a statement to the effect of, "Oh, you can kill somebody and pay a lot of money and get out of jail."
No further questions, Your Honor.
You should say that again.
Nothing other than argument, Your Honor.
Okay. All right, at this point, the rules of civil or criminal procedure as it relates to preliminary hearings, we'll get into the bond here shortly, but Mississippi Rule of Criminal Procedure 6.2 dictates that at the close of the prosecution's case, which has happened now, which includes the cross-examination of the prosecution's witness by the defendant, which also took place, the judge shall determine and state for the record or state in open court whether the prosecution's case established probable cause. So that's where we are according to the rules at this particular point. Ms. Gregg is charged with count 1, first-degree murder that she had feloniously caused death to Ashley Nicole Smiley. Charge 2, attempted murder that she did attempt to cause death to Heath Smiley, shooting him with a handgun. Those are the 2 charges. As I mentioned earlier, the standard burden of proof in a preliminary hearing is just what is reasonable. Based on the testimony of the investigator, I do believe it's reasonable to believe that the crime of first-degree murder has been committed. I do find it reasonable to believe that the crime of attempted murder has been committed. I also find that it's reasonable to believe that Carly Madison Gregg committed the crime of first-degree murder. I do also believe that it's reasonable to believe that Carly Madison Gregg did commit the crime of attempted murder. I am therefore going to find that probable cause exists on both charges to proceed in this matter. I'll bind Ms. Gregg over to waive the actions of the grand jury. That being said, the rules of criminal procedure at this point dictate that the defendant may then make a specific offer of proof, including the names of witnesses who would testify, or the defendant may produce the evidence offered. So, as it relates to the probable cause hearing, do you have anything at this point?
No, Your Honor.
Okay, that'll conclude the preliminary hearing in this matter. Now we will talk about bond. So either Ms. Todd or Mr. Coleman, whichever one of y'all wants to argue your bond argument.
I love how this judge explains the court rules before he makes his ruling, and explains the courtroom and the standard of proof and the burden of proof before he even starts conducting the hearing. This is refreshing. It's a completely different than anything that we're used to, and I'm here for it.
Carly's precinct bond is currently at $1 million. Carly is 14 years old, has no prior criminal history, and prior to the incident on March 19th, no prior history of violence whatsoever. To the contrary, prior to the incident on March 19th, Carly was an exceptional student with good behavior. In fact, she made a 30 on her ACT at the age of 13. She had skipped the 4th grade, so while she is now a sophomore at Northwest Rankin High School, she should be, according to her age, in the 9th grade, a freshman. Carly also was student of the month and I believe student of the year at Northwest Rankin High School prior to this incident. Carly,
Student of the month and student of the year. She skipped a grade. She was in 10th grade, should have been in 9th grade. Highly intelligent.
has no job, she has no passport, no driver's license, and no vehicle, so she's certainly not a flight risk. Moreover, all of Carly's family, most of which are here today in the courtroom, Your Honor, live either in Rankin County or the surrounding communities. Carly doesn't have family out of state, nor does she have a way to get there. Also, this has been a very public or more public crime. So Carly's face is known to most people. So if she were to run, she would be easily recognized. But if she ran, it would be on foot. So she probably wouldn't get very far before she was picked up. Moreover, Carly turned herself over to law enforcement after this incident occurred by flagging down a patrol car. She has demonstrated a history of a willingness to turn herself into the court. Since she's been detained, she's not been in any trouble, caused any concerns over the detention center other than the medication having to be adjusted multiple times by a nurse practitioner and a psychiatrist. Carly does not have a job, an income of any sort, a bank account, or any assets. She does have family that will support her, and both her family members, including her maternal grandparents, maternal aunt and uncle, maternal cousins, and also her stepfather, support Carly's bond being reduced.
So even her stepfather, who she attempted to murder, is in support of her bond of $1 million being reduced, as are her maternal grandparents and very many of her relatives. And the courtroom in this hearing is packed with relatives. And if they don't show the gallery, I'm going to show you a photo of the gallery.
Carly is currently being held, as the court noted earlier, in almost complete isolation for 23 hours a day. Today was the first time she's seen the outside in nearly a month. This type of extreme isolation is very difficult on adults to bear, let alone someone with a fragile mind state that Carly has right now. She cannot be provided with the mental health care that
She's in solitary for 23 hours a day. Her attorney, her name is Bridget Todd, said during this hearing that this is the first time she's seen daylight in over a month. We're seeing the outside.
she needs at her current detention facility, but she could, if she were released on a secure bond or placed on house arrest with an ankle monitor. These alternative options that are available to the court with those secure courts, with those secure Carly in a restricted confined area, which would keep her from being flight risk and would also help protect the public and Carly. Moreover, Carly's family supports her being released on house arrest, so that she can get the mental health care that she needs, and also have to contact her family members. There's also can be other restrictions that the court keeps in place as far as when she can or if she can leave the confines of a residence, social media contact, things of that nature. But Carly could also be allowed to continue attending school online while she waits indictment. It can be months before she's indicted, and at the current bond, with no income, no assets, no ability to raise those funds, nothing to sell, get those funds, not even a check to write, because again, she has no bank account. Carly is basically being fired from home, and it's nothing short of punitive. She has no means of raising these funds, and that's why we would ask that consider reducing Carly's bond to something that she could afford, and we would ask for an unsecured bond.
Here you can see the gallery. These are all relatives of Carly in support of Carly.
Moreover, detention center that's meant for adults is not equipped to do things like provide Carly with schoolwork, with mental health care, with exercise. Well, currently, she doesn't even have the ability to meet with visitors, as the courts were aware of. Based on Carly's fragile state, she's already taking medical term, and we've not even got the indictment. If it continues at this rate, Carly's fitness to stand trial will be at risk by the time we get to the trial. And again, the living victim's family, the living victim and the deceased victim's family support the bond reduction.
Her attorney says they all support bond reduction, the family, both sides.
Your Honor, unfortunately, you forfeit some rights when you kill a person and try to kill another. Schoolwork is well supported. I think you kind of forfeit that right when you murder someone. Your Honor, you talk about unsecured bonds, you talk about mental health, and just the court's knowledge, the state offered to stipulate to a mental evaluation for This has been said, look, you get this done by Friday, stipulate will agree, we get her evaluated. It seems that's what we're arguing here today, but she has no problem. And, you know, they did not agree to that. So you know, I think it's disingenuous to say on one hand she has no problems with these mental health, and on the other hand, will not agree to an evaluation. So that offer expired on Friday. And, you know, since the door of bond has been open, Your Honor, as the court is well aware, pursuant to Article 3, Section 29, when a person commits a capital offense, bond can be denied. So our response, Your Honor, is bond should be denied. I understand the family's been through a traumatic event that nobody wants to go through, and I feel so sorry for what they're going through. The state also has an obligation to protect the community at large. And based on what the state has seen and what has heard through the testimony, Your Honor, it would be unfathomable to release this defendant on bond today. Your Honor, the state also anticipates possibly a tampering of evidence charge that may come, as you report as well, where you heard about the video that was taken and hidden and tampered with, that is evidence in this case, and there may be other charges coming. We talk about her not having a car to flee. Well, that's one thing to worry about. The state is, number one, worried about the danger she is to the community. But it's also legal to shoot somebody, as the court is well aware. So what's to stop her from doing another legal act of getting in a car, which is legal, stealing a car, and going away? You know, if we're opening that door, that's where we're going. But if you look at the factors on bond, which the court is supposed to go to, that's Rule 8.2, right to release. And I didn't hear a whole lot of specific allegations on that. The state, when we're talking 3, Section 29, the state asked that you deny the motion to reduce bond. In fact, the state asked you to hold her without bond pursuant to Article 3, Section 29.
So do you have a pending written motion for Article 3, Section 29?
The state followed me, it's just she's opened the door, but we're making a ordinance motion to deny bond.
Okay, and that's fine. I just want to make sure I'm clear, but that's your tennis motion.
Yes, sir.
Okay. All right, Penny, your vote, Ms. Simon?
Yes, Your Honor.
So her attorney is arguing that she's not a flight risk. She's being held in solitary 23 hours a day. She's not able to do schoolwork while she's in jail. Her whole family supports the bond being reduced. And because of that, her bond should be reduced so that she can be let out. And the prosecutor, as you just heard, said, yeah, you lose certain rights when you kill people. And therefore, she's still a flight risk. She committed murder, an attempted murder, allegedly, because innocent until proven guilty. And therefore, judge, you don't have to reduce her bond, which was set at $1 million. Again, if you're just joining, welcome. This is the preliminary hearing that was held April 16th of 2024 for Carly Gregg, age 14, who shot and killed her mother and then laid in wait and shot and tried to kill her stepfather. He survived. After she shot her mother, she called her friend to come over to show her friend her mother's dead body. Then her friend went out into the backyard. Carly had texted from her mother's phone her stepfather to see when he was coming home. She laid in wait for him and shot him 3 times in the shoulder or neck while her friend was outside in the backyard. She's being tried as an adult in Mississippi. It's scheduled to start September 16th, and this is our pre-trial prep.
Dr. Webb will be conducting a mental health evaluation on Carly. He's currently out of the country once he returns on April 22nd. As the court knows, he's a very well-respected psychiatrist who works with children, and we lined him up. So, also, Your Honor, since Carly has been detained, her medication has changed twice, and these are not blood pressure medications, these are mental health medications. One has included a mood stabilizer since she has been detained. And that was after she reported hearing voices. Again,
She reported hearing voices while she was in jail. Did you hear that? They changed her meds twice, and her attorney is arguing this is not a joke. This is not blood pressure medication. These are psychotropic or psychiatric meds. And she reported hearing voices in jail. Let's take it back a sec.
a mood stabilizer since she has been detained. And that was after she reported hearing voices. Again, the detention center is not equipped to deal with that. It was a nurse practitioner who prescribed the mood stabilizer, not a psychiatrist. Secondly, Carly is not a threat to the community at large. Carly's family, including stepfather, who was indeed a victim here, would attest that he does not believe Carly still be a threat to him or to anyone at large, but she does need help. Secondly,
Yes, thank you, Emma, who says it's mind-numbing that her stepfather supports her. The attorney just even reiterated, he doesn't think she's a danger to him anymore. Something's going on here, and I need to find out what it is. I have so many questions.
there isn't a charge worse than murder. So once you're charged with murder, I don't see a charge of tampering with evidence causing you to flee jurisdiction. It's condemnable from there. Also, with proper restrictions, Carly would not be able to leave the confines of a residence. She would have no means of transportation. This is confined her from not having a cell phone so that she could not communicate with friends. All of this would keep Carly restricted and again, secure Carly and protect the community from whatever concerns there may be. But Carly's certainly not a flight risk, and she certainly doesn't have funds to raise the current bond. But she needs more help that can be offered to her incarceration.
Thank you. I'm assuming, Ms. Todd, it's fair to say that the family of Ms. Gregg that sits behind you, can I just see a hand of the family members? Is it fair to assume that family members, your argument, you appreciate that, is it fair to say, well, let me ask you this way, anybody that held your hand up, you disagree with anything Ms. Todd said concerning Ms. Gregg? Anybody of the family disagree with Ms. Todd? Okay, that's right, I just want to be sure.
All right,
All right.
so they didn't show the gallery, so I want to show you the gallery. Thank you again to Jackson Jambalaya for all of the amazing independent journalism on this case. Here's a large photograph of her family members in the gallery. When asked, Judge Morrow asked the family members present to raise their hands if they supported reducing her bond. This is what the courtroom looked like. So there you go. Oh, well, I'm showing it to you, but oh yeah, it's on the screen. Okay. It's not on my screen. Interesting. Nearly all of them have their hands raised. Did they all know that something was going on with this child? Similar to the family members of that recent Georgia school shooter?
Well, there's several reasons for bond, and I feel like I've been instructing today more than I typically do, but bond is not intended to be a punishment in and of itself. It's a balancing act, and that's why I tell people all the time it's a lot easier for me to follow the rules as it relates to these matters because they're also factually different. As the state pointed out, Mississippi Rules of Criminal Procedure 8.2 dictate, it talks about the right to release, which is in subparagraph 1, and it talks about that there are several reasons for release. One, we have to be assured of the defendant's appearance as required, or that the defendant's being at large will pose, whether it poses a real and present danger to others or to the public at large. And in that calculation, it goes through 15 different items that need to be considered, which I'll briefly go through for purposes of the record. Ms. Gregg is 14, about to be 15 if she's not already. It's her birthday in April. She does, I do appreciate her intellect and her success at Northwest Rankin. She clearly has a lot of family ties and relationships. So I think that factor one would weigh to the benefit of Ms. Gregg. The second one is the defendant's reputation, character, and health. I have found or heard nothing that would be a negative connotation as it relates to Ms. Gregg, so I would find that be a neutral factor. The third factor is the defendant's prior criminal record and any releases on recognizance or bond in the past. There have been none of those things. Those would be to the benefit of Ms. Gregg. The identity of responsible members of the community who will vouch for the defendant's liability. We just had a show of hands with family members. There were numerous family members here who support Ms. Todd's argument about the issue of bond. That factor would weigh in the benefit of Ms. Gregg, whether violence or lack of violence in the alleged commission of the offense. Well, that's significant. The violence is significant. Not only is the best evidence today, the testimony was that the violence with the mom was to such an extent that it doesn't appear to be any great argument prior to it. It seems to me that the defendant walked into her bedroom where her mother was and shot her 3 times, twice in the head. So, and then laid in wait, played with the dogs, laid in wait for nearly an hour waiting on stepdad to come.
She played with the dogs for nearly an hour waiting for the stepdad and sang to the dogs. This is chilling. You're right.
In and then shot him multiple times, or shot at him multiple times, striking him at least once. So violence is pronounced. The violence is significant. That clearly weighs against Ms. Gregg. The nature, item 6, the nature of the offense charged, the apparent probability of conviction, and the likely sentence. Insofar as these factors are relevant to the risk of non-appearance, it's a murder. It's a first-degree murder charge. It is an attempted murder charge. Probability of conviction is high. The likely sentence is going to be significant. I understand because she's a minor at the time the events were committed that there may be some leniency on the back end of that, but in any event, the likely sentence is going to be long-term, and they are relevant to the risk of non-appearance. That factor would weigh against Ms. Gregg. The type of weapon used, it was a handgun used here. I believe it sounds like a revolver, but in any event, it doesn't matter.
It's a handgun. Somebody had said earlier in the chat it's a shotgun. So let's try and stick with facts. It's a handgun. And people are saying where'd she got it? It appears she got it from her mother's room because there's video of her going into her mother's room, I believe, then coming out with something behind her back and then going into her room because her mother was looking through things in Carly's room. And I don't know if that had some sort of triggering effect or if she had been planning this for a while, but shot her in her room, in Carly's room, after Carly came with the revolver from her mom's room. So I guess that's where it was. I guess it was the mom's or the stepdad's gun. Not quite sure yet, but it was some sort of handgun.
It was a handgun that was used against both victims. Number 8 was the threats made against victims or witnesses. That's not applicable here. Number 9, the value of property taken. It's not applicable. Number 10, whether the property allegedly taken is not applicable here. Number 11, residence of the defendant, including consideration of real property ownership. Think of residence in the defendant's domicile. Ms. Gregg is a Rankin County resident. She's too young to own real property, and I would assume she spent most of her life here, but at least we know the last couple of years apparently. That factor really is of neutral content. Number 12, the case where the defendant is charged with a drug offense, that's not the case, so that's not applicable. 13 is consideration of the defendant's employment status and history. We have, as Ms. Todd pointed out, she's 14 years old. She has no employment. She has no work history, so that's a neutral factor. Number 14, sentence enhancements, if any, including the charging document, which we don't have at this point. Number 15, any other factor, circumstance varying on the risk of non-appearance from the danger to others or to the public. All right, that brings me to Article 3, Section 29, which the state has made a more intense motion to deny bond to the defendant. And Article 3, Section 29 of the Mississippi Constitution indicates that in paragraph 2 and 3, paragraph 2 dictates that if a person is charged with committing an offense is punishable by death, life imprisonment, or imprisonment for 1 year or more in the penitentiary, and that upon hearing finds probable cause that the person has committed a felony on line. That really doesn't apply. That's paragraph 2. We go to paragraph 3. It charges an offense punishable by imprisonment for a maximum of 20 years or more, or by life imprisonment, which is certainly applicable here. A county or circuit court judge may deny bail for such offenses where the proof is evident or the presumption great upon making a determination that the release of the person arrested would constitute a special danger to any other person in the community, or no condition or combination of conditions will reasonably assure the appearance of the person is required. I do believe that Ms. Gregg does pose a special danger to others. I mean, I know the family knows better than I do, but the heinous nature of the crime, the premeditation that seems to have been involved here is pronounced. It's severe, and it does concern me. It does concern me that there is a danger, Ms. Gregg, whether there's a mental component to this or not. I think anybody could argue that if you're going to kill another human being, then there's going to be a mental component involved in most of those crimes where someone's murdered. But anyway, the particular facts and circumstances of this case do cause me pause. While I do appreciate the state's petition or argument about denying for bond, I'm not going to deny bond under Article 3, Section 29. So I am going to bond guidelines, which is the Mississippi Rules of Criminal Procedure 8.2C, or bond guidelines, which the state provides, which are presumptively reasonable. The defendant has made an argument for an unsecured bond, which is completely inappropriate on a murder charge.
Nice try, though.
Would be you could have absolutely no money, and they would have no skin in the game, as I call it, for appearance purposes or risk purposes. So that would be clearly off the table. 8.2C, the bond guidelines dictate that for a capital felony, the bond guidelines are $25,000 to no bond or no bail allowed. Manslaughter or any other non-capital crime involving the loss of human life, $10,000 to $1 million. It's easily, and then the non-capital offenses punishable by maximum 20 years or more, $20,000 to $250,000. $1 million is on the high end of the range, but it is within the range. I have some compassion for the defendant's particular status in life, being young and being exposed to this. I do find that, I do believe that it is difficult to be in isolation 23 hours a day. I get that. I don't think I would enjoy that either. But as the state points out, when you commit crimes of this nature with the violence involved in this crime, with proof being so heavily weighed against the defendant, even at this point, that there is too much cause for concern on my behalf. I will leave the bond at the upper end of the range, which is $1 million at this particular point, and I will be open to anything changes down the road. If we end up with more information, more facts, Ms. Todd, I'm happy to.
What I also love is how the judge explains his reasoning for every ruling that he's making from the bench. JP Eagles and Cats, I know we're used to watching the Karen Reed trial for however many 9 weeks or however many weeks we watched with Judge Cannoni, who JP Eagles said would have dismissed court, thought about it for 3 weeks, and then ruled from behind her laptop. This is a whole new world here in Rankin County, Mississippi.
Revisit the situation later. If we have different facts that come up, different circumstances, or different things that we know about as they exist today. So I am going to set a bond at $1 million collectively for the 2 charges. In addition to that, were she to bond out, she must appear at court when required by all orders of the court. She has to notify the court of any change of address. She cannot commit any other crimes, which usually is the one that trips people up. Not possess, be in the presence of weapons of any kind. She has to be involved in an online school system. If she does make bond, she has to obtain an alcohol and drug assessment and comply with those recommendations. Cannot consume alcoholic beverages, illegal drugs, or misuse prescription drugs. She can have no contact with Heath Smiley until released by court if she makes bond. She also has to obtain a one-piece no-cut fiber GPS ankle monitor. And in that monitor, she has to keep it operable and charged at all times. If she has a passport, she has to surrender it to the circuit clerk's office within 48 hours of release. She has to abide by a court order curfew of 10 p.m. to 6 a.m. And until final disposition of the case, she has to maintain that GPS monitor. She will be subject to continuous monitoring by court watch or correctional counseling. Mississippi, and she has to continue to follow the directions of the mental health physician. These are all assuming that she finds out at this particular point in time. All right, but that disposes of those issues today. Anything else, Ms. Todd?
Your Honor, other than she's not allowed any visitors while at the detention center. However, I believe the maternal grandparents would like to visit her.
All right, I'm gonna tell you the same thing I told Ms. Walker a while ago. When you leave here, if you go behind to the jail, hit the intercom button, talk to Jordan, and just tell Jordan you just left out of here. I talked to Jordan in the hall earlier. He understands there's a large presence of family here. He's gonna try to accommodate some limited contact at that point. So go try that, and if for whatever reason that doesn't work, let Anita know. But we're aware of that. We're gonna try to make that happen.
Thank you.
Okay. Anything else, Mr. Barry?
Yes, sir. That's just for today, correct, Your Honor?
Yes, sir.
Thank you.
So the only thing the defense got.
Conclude, the matter in 24-15875.
The only thing the defense got during the course of that hearing was that she was allowed to see visitors. He kept the bond at $1 million, and he reasoned his way through it. We understood. We got it, which is so unlike other cases that we cover. This judge is a refreshing change. I want to show you this. Also, Jackson Jambalaya, who says in this article, where is it? Here's her mug shots. She looks like a baby to me. Here she writes, when yours truly was taking pictures, the defendant actually posed. Yes, posed for the picture, even smirking. The facts of this case are pretty clear. Carly Gregg allegedly killed her mother when her mother took something in her room, played with her dogs, called over a friend to show off the body of her mother, and then lay in wait for her stepfather as she got ready to kill him. Evil, says this reporter. And here's the photo. Caption, posing for the camera. Say you. Chilling. This case is chilling in so many ways. So there was another hearing. This was in April of 2024. Then there was a May 14th hearing. Let me see if I queued that one up. A moment. Talk amongst yourselves for a second. Let's take a look at some local news coverage. Let me see what I have here for you. The May 16th hearing. Let's go to the chat for a second, see if you guys have any current questions, concerns. Good morning, Joanna. Thank you for the super chat. Why don't they check if she's a psychopath? It's easily detected with an MRI, and it's not an excuse. Can you detect if someone is a psychopath through MRI? I don't know enough about that to opine, but thank you so much for the super chat. Thank you, Wendy Darling, for your super sticker. Appreciate you always. So very kind and generous. Blackbird Squeaks, thanks for the 10. What happens is their academic intelligence is mismatched with their emotional intelligence, personal experience with my kid. It's a recipe for disaster. Thank you for sharing. And I don't know that being a younger kid in an older grade helps necessarily. Thanks, Elf, for gifting a membership. Thanks, Nancy, for joining and for chiming in the chat today. Have I ever thought about being a judge? Yeah, for like a half a second, many years ago, when I was deciding to pivot from practicing law to doing other things after the cases I handled against the Catholic Church sucked the life out of me. That was a 15 or 16-year fight. I did think about it for a minute. Here in New York, our judges are elected, and so it's very political. It's very political, and it would have been a huge pay cut. Judges don't make a lot of money. It's an interesting concept, but I did actually have somebody start looking into it for me and like an exploratory committee. And it was just so like, unless you had been donating lots and lots of money to one of the political parties out here, it just wasn't really an option or really something that I would have been interested in at the time, a long time ago. Fun idea for a stream, says CH. You and Andrea Burkhart discussing current cases, dropping in dead lyrics as much as possible. Game show counters to add to the fun. Is Andrea Burkhart a deadhead? I had no idea. Is she? I did not know. That's super cool. Glarer. I'm still trying to understand the judge's rationale for wanting the trial of a minor televised or streamed. Maybe it doesn't matter if she's being tried as an adult. Well, interesting that you say that, because there was a motion made to exclude the public and the media that we're going to take a look at. That was filed in this case, and then we're going to take a look at the hearing as well. And that motion was filed back in May of 2024. So first, let's take a look at the motion, and then I believe I have that hearing queued up. And I'm sure that the judge is going to completely explain his rationale to us, because that's what this judge does. Again, courtesy of Jackson Jambalaya. I've put their YouTube link in the chat for you so you can support. Here is the motion to reduce bond. Let's see if we can get this bigger for you. It's about as big as it wants to go right now. And this is, again, State of Mississippi versus Carly Madison Gregg. Motion to reduce bond. Wait, that's not the one we were looking at. That's the hearing that we just watched, which was the motion to reduce bond. Hang on. Wrong pleadings. 1 second. There was also a motion for a gag order that was filed. I'm assuming that was denied as well. And I had too many tabs open and I must have closed it. But let's watch the hearing, shall we? Instead of reading the papers. One of these days I'm going to get my act together. I'm not feeling that great today. All right, let's see. This was a hearing from May 14th, 2024.
The first charge that you have is first-degree murder. The second charge you have is attempted murder. You have been detained at this point of 56 days. Your current bond is $1 million. You recently turned 15 this past month. The same thing is true here in analyzing the circumstances for Gregg. She is 15 years old. Her mental maturity, physical maturity, or present mental state, I've heard no adverse information concerning that at this point, although I do note that it has been brought to the attention of the court that you have excellent academic record, which is good, but I've had nothing negative up to today, which we may have more information presented today. The other criteria of the nature and circumstances of the alleged offense, obviously a murder charge, a attempted murder charge, are extremely violent charges, and they are held in the most serious of circumstances here. There are no prior delinquent acts by Ms. Gregg, and we do have the ability to separate her from the adult prisoners in the detention facility. I do note that typically we try to house 2 people in a cell at this particular point, but we have no other juvenile females at this point, Ms. Gregg. So regretfully, you're by yourself at this particular point. But in the interest of justice, I believe, is met by keeping Ms. Gregg pending her bonding out or change of custody, held in the adult facility, as I mentioned, or different from separate from the adult prisoners here. All right, Ms. Gregg, we're going to talk about some more of your cases, so we can take the front row back.
So this was actually her second detention hearing. That was in May of 2024. And because of her age, they need to have a detention hearing every 30 days. And they're excusing the rest of the prisoners from the courtroom.
And Ms. Gregg, if you want to come down and sit next to your lawyer over here.
At least the audio is better on this one.
Okay. All right, we're on the record in 24-15875, State of Mississippi versus Carly Madison Gregg. We have several things that we need to discuss concerning Ms. Gregg today. We have to cover with Ms. Gregg today. And you're Mr. Coleman. Sit down, Mr. Coleman. You're going to be a minute. First thing I want to cover, and you can speak to me from sitting right there, Mr. Coleman, is MEC 49 and MEC 50 as it relates to Ms. Gregg, or the orders for mental evaluation. Have you had a chance to review those?
No, sir, we have not. But our retained medical doctors have informed us that they are unable to complete their mental evaluations and testing until Carly is released from jail.
All right, that's not going to be necessarily true. All right, so here's the way we can do that. And I understand that that's one of the concerns. And it's
He's not having any of it. They're like, yeah, she can't be mentally evaluated until she's released from jail. And he's like, no, here's how it's going to work.
certainly a concern, but we got 2 different things going on here. So I'm going to address what you said first, then we'll come back to Mississippi State Hospital. She can be either evaluated in jail, or if your psychiatrist or psychologist believes that she needs to come to his office, she can be transported by the court staff and deputy to his office for any evaluations. So her detention or incarceration will not prevent her from being evaluated. So if you're sincere about wanting her evaluated by someone of your own choosing, then you need to make yourself available for that, because as they say, the dog won't hunt going forward, because we will accommodate her being evaluated by your expert. Now, the second thing is the orders MEC 49 and 50. I want you to go back and look at those today, because both of those, MEC 49 is the order for mental evaluation for competence to stand trial. And the second page of that order specifically requires the defense counsel to promptly prepare and furnish to the examining mental health expert the following. Now, I understand he hadn't had a chance, I understand you'll have a report, but there are other things there that you can provide to the mental health facility at Mississippi State Hospital. And then once you do that, you're required by order of the court to file a certificate of compliance that you have done it. So both MEC 49 for the competence to stand trial and MEC 50, the supplemental order for analysis, both have affirmative requirements for the defense counsel to provide information to the state hospital and to file certificates of completion. The state hospital can't begin until you've done that. The state of Mississippi has already done that. They sent their material there, they filed their certificate. Is there any reason, Mr. Coleman, that you can't get this filed in the next 24 hours?
I would have to speak to Carly's medical examiners, Your Honor. I'm not aware of their schedules. I'm not aware of their availability. Certainly, I'm willing to reach out to them and see if we can expedite that process.
All right, my patience is going to be a little thin, Mr. Coleman. The order says 10 business days from the date of the order. April the 18th was when the order was entered. So we run out of 10 business days since the entry of the order, and this is obviously a most serious event. And while you certainly have a right to have a mental evaluation done, the state of Mississippi has a right to have a state hospital perform one as well. And I'm not going to allow you to obstruct that process. I'm not accusing you of obstruction. I'm just telling you right now we have non-compliance with my orders. All right. Today is Tuesday. I'm going to review this next Tuesday, Mr. Coleman, and I expect when I pull up MEC to find certificate of compliance for both MEC 49 and MEC 50 that says that to the best of your ability, you have complied with the orders of this court. Now, if you have not provided those by next Tuesday, then I'm just going to get up honest with you and have a show cause hearing. I'm serious as I can be about this. This is a serious matter. I need your cooperation. I will have your cooperation, whether you cooperate or I have to make you. I'm not trying to be ugly. I'm just trying to tell you.
Whether you cooperate or I have to make you. He says, I'm not trying to be ugly. It's like the Mississippi way of bless your heart.
How serious this is, okay?
Understood, Your Honor.
Okay, all right, that's fair enough. All right, now then, let's move on to the two motions that the defense has filed. We got two items on the agenda of the docket today. One is MEC 53, which is a motion to reduce bond filed by the defendants on this past Friday, May 10th. That was MEC 53, and a motion to exclude the public and the media, which is MEC 56. According to the Mississippi Rules of Criminal Procedure 1.3d, it states that a written motion and notice of the hearing thereof shall be served no later than 5 days before the time fixed for the hearing. The notice of hearing for both motions was today. The motion to exclude the public and the media was filed yesterday, the 13th. We clearly are not within the, we've not had the requisite time here. Mississippi Rules of Criminal Procedure 1.3a specify that when the period of time prescribed or allowed is less than 7 days, which is what we have here, that Saturdays and Sundays don't count. So we don't count the day of the filing, but if I did count the day of the filing for MEC 53, which is the motion to reduce bond, then we've only got 3 days. If I count the day of filing yesterday, which I'm not supposed to, but if I did, for the motion to deny access to the public or press, then I've got 1 day on that clock. So, all that to be said, Mr. Coleman, the rules of criminal procedure have not been followed as it relates to notice on those two motions. That can be cured by the state of Mississippi if they choose to waive time in this event. Mr. Berry, what's the state's position on these two motions?
Your Honor, as to the motion to reduce bond, I spoke to Mr. Coleman beforehand and tried to talk to him about that. And the state does not choose to waive that at this point. And generally, when we choose not to waive that at this point, it's a motion to exclude the media and the public. Your Honor, we defer to the court on that, as to this motion.
Okay. Well, I tell people all the time that it's a lot easier for me if I just follow the rules. And they're,
Imagine that. It's a lot easier for me to just follow the rules. I love this judge. He's not having any idea. He's like, your motion's late. I'm not going to consider it. We're going to put it over so that they have time to respond. Let's take a look. I found it now. Let's take a look at the motion to exclude the public and the media that was filed in this case. This is again the state of Mississippi versus Carly Madison Gregg. Motion to exclude the public and the media. Comes now the defendant, Carly Madison Gregg, Carly, by and through her counsel of record, and files this motion to exclude the public and the media from the courtroom during the hearing on the motion to reduce bond, and in support thereof would respectfully show unto this honorable court the following facts and matters, to wit. 1. Carly is a child who is currently experiencing fragile mental health. 2, the hearing of this matter raises privacy considerations under the HIPAA Act, as Dr. Mark Webb and Dr. James O'Brien may be called to testify regarding Carly's health. 3, Carly's defense counsel intends to call a family member to testify who is deeply grieving, and the presence of the media would further traumatize and emotionally disturb this family member. The court has recognized that the public exclusion may be appropriate to the extent necessary to avoid embarrassment or emotional disturbance to a witness, which might result from that witness giving testimony in a particular case, citing 2 Mississippi cases. 4, this family tragedy should not be fodder for the public's entertainment. Wherefore, premises considered, the defendant requests an order excluding the public and the media from the courtroom during the hearing on the motion to reduce bond. The defendant prays for any additional relief to which this honorable court deems appropriate in the premises. Respectfully submitted. This was the 13th day of May, 2024. And the judge said you did not give enough notice before that hearing, which we just watched, which was May 14th. So it went to another date. Let's take a look here. This is the motion to reduce bond. 1, Carly is currently 15 years old. Her bond is currently set at $1 million. Carly has not been indicted. 2, Carly was arrested and taken into custody on Tuesday, March 19th of 2024, after she flagged down a patrol car, and peacefully turned herself over to law enforcement. 3, Carly has no prior criminal record whatsoever, nor does she have a history of violence. 4, to the contrary, Carly was an honor roll student and student of the year at Northwest Rankin High School prior to her arrest. 5, Carly has no income, no bank account, and no assets. 6, Carly does not have a driver's license, a car, or a passport. 7, Carly does not possess the financial means or resources to raise the funds required to pay her current bond. Carly's current bond is excessively high and set at an unreasonable amount, citing another Mississippi case from 1979. 8, the state charged Carly as an adult. Therefore, Carly has been detained in solitary confinement and not allowed visitors, with the sole exception of her attorneys, or the ability to speak with anyone for 23 hours a day. Carly's been isolated under these conditions for nearly 2 months as of the date of the filing of this motion. So this motion was a month after the first hearing that we watched, where they argued all of these same points. This extreme confinement and isolation is deteriorating Carly's mental state and is punitive. 9, Carly has been detained in solitary confinement for nearly 2 months without being indicted. 10, Dr. James O'Brien has been retained to conduct a psych evaluation and testing on Carly, but this evaluation and testing cannot be done while Carly is in jail. 11, Carly has been charged as an adult, but adults charged with the same crime as Carly are not being held in the same form of extreme confinement. 12, children who are the same age as Carly and in the same grade as Carly and who attend the same school as Carly have been charged with the same crime as Carly, but have received much lower bonds. Please see attached Exhibit A, examples of much lower bonds set for children who face the same charges in the Tri-County area. 13, both the living victim, that's the stepfather, and the family members of the deceased victim support Carly's bond being reduced. 14, Carly is not a danger to herself or the community. There is no risk of Carly fleeing the jurisdiction, and she has already demonstrated her willingness to turn herself in to law enforcement. 15, Carly has lived in Rankin County for years. Her family members, school, and friends all reside in Rankin County and the surrounding areas. 16, alternative options are available to restrict Carly's movements, protect the community, and ensure Carly's courtroom appearance. Such alternative options would also allow Carly access to necessary mental health care and enable her to continue attending school online until her indictment and/or trial, while releasing Carly from solitary confinement on an unsecured bond. 17, Carly cannot possibly pay her initial bond amount. Bond is not meant to force a defendant to rot in jail until his or her case can be heard. Refusing to reduce Carly's bond effectively denies her the right to a bond and leaves her in pretrial detention, even though she is not a flight risk or a risk to the public, which violates the 8th Amendment of the United States Constitution. 18, Carly has the benefit of being deemed innocent until proven guilty. Wherefore, we respect the court reduce her initial bond to a reasonable amount, and to give Carly an unsecured bond based on her circumstances. XOXO, Caleb Coleman, attorney for Carly. There's the certificate of service. And there's an order for a mental health evaluation from the judge. And here is an affidavit. We looked at the indictment earlier, so we're not going to go through that again. This was filed on March 20th, the day after the shooting. And this was the affidavit of Zachary Cotton, who we saw on the stand before at the preliminary hearing. And his sworn affidavit says, on or about March 19th, 2024, in the county aforesaid, Carly Gregg, date of birth 4/23/09, did unlawfully, willingly, and feloniously violate the state laws to wit, did feloniously, willfully, and unlawfully with deliberate design to cause death to Ashley Nicole Smiley by shooting her in the head with a handgun, causing the death of Ashley Nicole Smiley. That is her mother, for those of you just tuning in. This is in violation of Mississippi Code and the sections and against the peace and dignity of the state of Mississippi. He does not mention the attempted murder of her stepfather in that affidavit. Here is what they are calling the underlying facts and circumstances. On March 19th of 2024, the Rankin County Sheriff's Office received a call in reference to an individual who had been shot at 214 Ashton Way in Brandon, Mississippi by their daughter, Carly Gregg. Upon arrival, so people were asking who called 911. It was the stepfather after he'd been shot. Upon arrival, deputies discovered that Carly Gregg's mother, Ashley Nicole Smiley, was deceased, having suffered a gunshot wound to the head, and her stepfather, Heath Smiley, had suffered a gunshot wound to the shoulder. Heath Smiley informed responding deputies that when he arrived home, he had found his wife on the floor in Carly's room, and when he turned around, Carly was standing in the kitchen with a handgun. Heath stated that Carly fired approximately 3 times, striking him once in the shoulder. He stated that he and Carly struggled over the firearm, and he was able to get it away from her. After having the firearm taken away from her, Carly proceeded to run out the back door of the residence and jumped over the fence. Additional law enforcement began to observe the area and was able to take Carly into custody a short distance away from the residence. Due to Carly Gregg discharging a firearm, causing death to Ashley Smiley, and discharging a firearm, striking Heath Smiley 1 time, she is charged with a violation of Section 97(3)(19) murder and 97(1)(7) sub 2 attempted murder of the Mississippi Code of 1972 as annotated. The offense occurred within Rankin County, Mississippi, and that was signed by Zachary Cotton, the investigator, and sworn to the day after the murder on March 20th of 2024. And then there was a bench warrant issued. Let's go to the chat for questions before we take a look at the hearing regarding media coverage of this case. A lot of people are behind, so the comments are at things we cover about things that we covered previously in the stream. So welcome. And you guys will hear me later say welcome to you, because you probably can't hear me now. Let's take a look at that motions hearing on July 23rd of 2024. This was regarding media coverage of the trial, because a lot of people had questions about, because she's a minor, why is this being broadcast? She's being tried as an adult. So let's hear the judge's reasoning on this issue. Notice now she's wearing civilian clothing. They're dressing her in what looks like a school uniform, a Catholic school uniform of some sort.
Before the court is the defendant's motion to exclude the public and media, NEC number 12, and defendant's submitted motion to exclude the public and the media, NEC number 35. The court's read and considered all the motions and responses, including Court TV and Gregg Media, Incorporated, DBA, WLBT's motion to intervene and oppose, MEC numbers 19 and number 56. Primarily, the defense raised 99-43-101. There's one citing case of that. That's Pitts versus State, which was tried in this very courtroom. In that case, it was the witness was a victim of sexual assault. If I remember correctly, it was her father.
Okay, that's chilling. Oh, just a quick interruption of your stream to say happy birthday to Scott, one of my amazing moderators who has a birthday today. Everyone say happy birthday to Scott. We love you. And I hope you have an amazing day. Thanks for coming in, even on your birthday.
Courts looked at 99-43-101. In particular, the court's looking at subsection B, the subsection I. It says any criminal hearing, criminal trial, or other criminal proceeding in the circuit county court in which a child testifies as a victim of a crime or as a witness to a material issue. All right. The right to an open and public trial is a shared right. It's a shared right of the accused and the public, and the common concern being fairness. This court is required to determine whether the rights of the accused override the qualified First Amendment right of access by the media and the public. First, this court would note that the very First Amendment to the U.S. Constitution is the fact that the government shall make no law abridging the freedom of the press. The time-tested manner of testing witnesses' statements is to require a public statement under oath facing penalties for perjury. This court is being asked to exclude the public. First, this court would note this is the public's courtroom. People of Rankin County own this courtroom.
This is the public's courtroom. The people of Rankin County own this courtroom. The U.S. Constitution is alive and well in Mississippi, seemingly, unlike some other states that we've looked at recently.
This judge, nobody gets. This court's not going to exclude the public. Second, the court's being asked to exclude all media. What the court has basically heard is that the arguments are that the family's tragedy is not fodder for public entertainment.
We just read the motion.
It's a terrible fact of humanity. I don't know why people are interested in cases sometimes, but they are. Back to Oedipus, King Oedipus, the Greek story, to William Shakespeare and the 16th century. People have been interested in jury trials.
Oedipus has entered the chat. Shakespeare has entered the chat. Petty Paralegal says this guy needs to run for office.
In this country, we have a media, we have the press, so things can't happen behind closed doors. As far as the impact on the family of the victim, this court often is faced, the defense counsel doesn't want the family having an impact on the case, because if the family's calling for sentencing for blood, then the defendant doesn't want blood. However, when you have a family that's calling for mercy, I don't know what to do in this particular instance. However, it can't be done behind closed doors.
That's right.
Just can't.
Amen.
As far as heightening scrutiny on potential jurors, the interveners have agreed, and this court will order that the jury list will not be released in this case. It will be placed under suit. If any potential juror at the close of this case wishes to be identified, that individual juror can step forward on their own. However, if the individual juror does not wish to be identified, then the list of the jury will be sealed and that juror will not be identified. Further, the rules of electronic proceeding, the Mississippi rules for electronic photographic coverage provide that the jury is not to be videoed in any manner.
Yeah, look at what is so interesting too. Okay, look at how they moved the attorney's tables to the right side of the judge. Look how now they're facing the back wall and directly facing what would be the jury box. And earlier hearings, I don't know if this is a different courtroom, but in earlier hearings, they were seated, as we usually see, facing the judge. Now they're to the side of the judge. It's an interesting setup.
There's not to be any still shots of the jury. The court will not allow the cameras in during jury selection. Bottom line is the court's not going to allow the jurors to be identified. The intervener has agreed to that. As such, that is an accommodation this court is making to alleviate the defendant's fear. However, as far as live streaming conversations of defendant and her counsel, the rules specifically provide that there's to be no audio recording of the defendant and her counsel. The court's not heard any evidence that that's happened. In fact, the court has heard exactly the opposite of that. Additionally, this court's taken some steps. The court has told the bailiff that a room behind the courtroom will be available to defense counsel and the defendant during breaks where they can sit, they can discuss trial strategy, they can have those conversations. Anything that a camera could pick up, a jury could pick up visually during the course of the trial. However, the court will impose certain limitations on the press in regards to audio recording of statements between defense counsel and her client and the defendant. All right. Court's made some other accommodations to lessen any potential impact on this defendant. Court has allowed defense counsel to provide her with clothing that is not jail-issued clothing. And the court has ordered has spoken with the sheriff's department, and they understand that she's not to be shown invisible restraints from today forward. In fact, she was not shown any visible restraints today.
Okay, she's not in any visible restraints, and they're allowing her to wear street clothes, and she looks like she's 10, in my opinion.
All right. After reviewing the motions, the responses, and the hearings of arguments of counsel for both sides, the court denies the motion to exclude the media and the public in these cities number 12 and 35. The court finds the following restrictions and or alternatives to closure will ensure both an open and public trial and that the defendant receives a fair trial. Therefore, is ordered and judged that the location of equipment and personnel necessary for electronic media coverage of judicial proceedings shall be in place either inside or outside the courtroom so as to be minimally intrusive to the proceedings. Only equipment.
Wait, what happened? They cut it off.
Welcome back. This morning, we're shining a spotlight on some.
The real no nonsense incoming shortly. I don't know. I guess it got cut off. I don't know what had happened there. That was weird. Hang on. Well, bottom line is he's going to allow the media in. This is the public's courtroom, he said. This is the county's courtroom. Let's see. Wait a second. Sometimes it skips ahead, so hang on. Yeah, no, it just kind of cut off. That was WAPT News, Jackson, and I'm not sure why. Two weeks ago, there was a competency hearing. If you'd like to see some more of this judge, we can watch that as well. I think we should. To see whether or not Gregg is competent to stand trial. I think we're going to be able to cover everything before this trial starts. Jury selection is scheduled to begin on September 16th, and there is another hearing next Tuesday, the 10th, to see whether the case will be transferred to juvenile court. So let's take a look at this hearing. wherein the judge is going to hear argument on whether Carly Gregg is competent to stand trial. And rule, actually rule, not take it under advisement, but rule. I like the setup of the courtroom.
All right. We're on the record, state of Mississippi versus Carly Madison Gregg, Rankin County, cause number 2024-34169. All right, first matter we have is a competency hearing. State may call its witness.
Judge, before today's hearing, we spoke with the defense attorney and they have agreed to stipulate the competency. Dr. Gugliano, Manny Gugliano is present in the courtroom. I told her she would be excused until that was done. And so we'd like to enter a copy of her report where she found that the defendant, Carly Gregg, is competent to proceed to trial into the exhibit to today's hearing.
Any objection?
Yes, sir. Yes and no, Your Honor. The exhibit, as it is right now, we believe is improper. It can be a redacted version needs to be entered at this time, Your Honor, per the rules.
Well, Mr. Kemp, you raised insanity. Therefore, I cited the rule in my order where you made the redaction. However, this is what the court's going to do. There is pretrial publicity on this case, so I don't believe that I'm going to accept it as S1 over the defendant's objection. However, I'm going to see it. I don't. There is a right to publicity, but the court's going to weigh that pretrial publicity against the defendant's right to a fair trial, and I'm going to seal only this report at this time. The objection as to redactions, I did double check the transcript. I asked very clearly, or do you intend to seek an insanity defense? She said yes. So that's the reason why I allowed the state to have an unredacted copy first. Second of all, they had retained Dr. Gugliano, so I felt like they were entitled to it. Now, we get into a situation at trial.
If you're not looking at your screen, just look at your screen for a moment. I'm so torn about this case because she looks like a baby. I haven't seen any body cam footage of any interrogation of her. I have never seen her speak, but she looks like a baby. And I don't know. I don't know what to think about this yet. I'm undecided for a change.
Portions of it may not necessarily be able to be used depending on the posture at trial. That's where we're going to be. Mark it for C1. Mark it's S1, but I'm going to seal it at the end of this hearing. Anything further from the state? That's competency.
Your Honor, the initial report, our motion in order asked that Dr. Gugliano prepare both an evaluation as to competency and to insanity and McNaughton. The state has filed an amended motion asking that we be able to retain Dr. Jason Pickett and that Dr. Gugliano essentially be relieved of her duties to perform that McNaughton analysis.
But nothing further as far as competency, correct?
No, sir.
And the defense does stipulate competency, correct?
That's correct, Your Honor.
Based on Dr. Gugliano's findings and the defense's stipulation, the court will find that this defendant is competent to proceed, and we will move forward. All right, now, there was an amended motion by the state that you just referenced. I'm looking for that motion.
I don't know what's up with
111,
coverage,
motion
but
for mental evaluation and McNaughton analysis. All right. So the state of Mississippi is asking that Dr. Gugliano be relieved from her obligation to perform a McNaughton analysis.
Yes, sir, Your Honor.
going to hire somebody else to perform the mental analysis.
Yes, sir, Your Honor. Dr. Jason Pickett,
Okay, what type of doctor is Dr. Jason Pickett?
forensic psychiatrist. Also, he has did his residency in emergency medicine as well.
Okay. Have you informed him of the trial?
Yes, sir, Your Honor.
All right. Anything further from the state?
No, sir, Your Honor.
Response by the defense.
First of all, Your Honor, when Dr. Gugliano went and did the, I guess, the competency hearing, she got halfway through her evaluation on not, they were just supposed to continue. So we don't understand why they're having to switch to somebody else when that person evidently is qualified to do it and was doing the investigation.
Dr. Gugliano here.
She is, Your Honor.
Yes, Your Honor.
Of course, we'll call Dr. Gugliano.
This isn't us. This is WAPT.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, and nothing but the truth?
I do.
Now, under that, can I ask you some answers of the question?
Yes, I do.
This is one more bit. Court's going to ask a few questions, then I'll turn it over to the state, then I'll let the defense ask any questions. Any objection to that by the state?
None from the state, Your Honor.
By the defense? There you go.
Yeah, Jam Cracker. Interesting. Wearing a school uniform for a school she does not attend. Manipulation squared. Right. She was a student at Northwest Rankin High School, where her mother was a math teacher. So she's a public school student. This is, yeah, interesting.
Dr. Gugliano, why did you not perform a mental analysis?
I started interviewing Ms. Gregg regarding a mental analysis, but we had been meeting for about 5 hours at that point, and there was a person sitting in the room next to us who we could hear, so I'm assuming that they could also potentially overhear us speaking. And so we stopped at that point, and I was going to reschedule. In working on my competency report and reviewing records that I had received, I believe on 2 days prior to my interview of Ms. Gregg, it seems that medications are going to be relevant to her mental state at the time of the alleged offenses. As a psychologist, I do not have expertise in medications or the potential side effects or impact that medications could have on someone's mental functioning. Therefore, I let Ms. Newman know that I thought it would be better to have a forensic psychiatrist perform the evaluation because they would be able to fully answer the question.
Look at that. A doctor who actually admits that she doesn't have the expertise or the qualifications to opine on something that she doesn't deem herself to be an expert in. That's refreshing too.
Sure. Turn the witness over to the state.
Dr. Gugliano, you were ordered to evaluate the patient. What records did you receive from the defense attorneys prior to?
The defense attorneys provided me with Magnolia counseling records from individual therapy that she was receiving.
And there was no prescriptions anywhere in those records, is that correct?
No.
Did they provide any additional records showing the prescription medication that the defendant was on?
No, they did not.
And so we provided those when we received them on August the 8th. Was that the first time that you talking about the use of any antidepressants or medication?
Actually, let me rephrase that. The counseling records did refer to Ms. Gregg being prescribed medication from Precise Neuroscience Center, I believe, or clinic, but I had not received those records yet, and so I wasn't for sure how accurate the records were that the counselor noted. I'm assuming that she was told about the prescriptions from Ms. Gregg, but I cannot say that for sure.
And as of this date, you still don't have any pharmacy records, is that right?
I do not.
And based off of what you told the judge, now that you know there were antidepressants that were prescribed, is it your testimony that you do not think that you would be able to complete the insanity portion of the evaluation?
It's not just that she had an antidepressant medication prescribed. It's based on the brief amount that we talked about what was going on with Ms. Gregg around the time of the alleged offenses, like in the months leading up to them. Her medications were switched, and so there may be a question of withdrawal from medications and how those may have interacted. So it's the fact that side effects or withdrawal symptoms from the medication could be relevant to mental state. That is my opinion, why I'm not the best expert to do that type of evaluation.
And as you sit here today, you can't say, Dr. Guglielmo, whether or not there were any withdrawals or that could actually be an issue.
No, I cannot. That's outside of my scope of expertise.
No better question, John.
Other things? No question. Is there somebody at Mississippi State Hospital that could have, whose area of expertise does that lie within?
It would be a forensic psychiatrist, in my opinion, because they have both the medical training and the forensic training to complete the evaluation.
I understand you no longer work at the state hospital.
I do still work at the state hospital, but I also do private work.
Is there somebody at the state hospital that does, that would be qualified? Or would it?
Dr. McMichael, who's the service chief, is a forensic psychiatrist. However, he has some medical issues going on right now, and he would not be available at this time.
Just that Dr. Jason Pickett does, in fact, does he also provide evaluations for the northern part of the state, sometimes through the state hospital?
Yes, he does. He's a Department of Mental Health certified forensic evaluator.
No.
Anything further for the defense? Negative. You stand. All right. Does the state have anything else in the way of requesting Dr. Pickett?
Other than this sort of hints on our other motion to compel, but we were told that we would receive a copy of a report from Dr. Mark Webb, from the defense attorney, back some time ago, including again last month, and we don't have that. And so we feel that we need Dr. Jason Pickett to go ahead and evaluate this analysis regarding any potential medication or insanity defense, even without receiving a copy of Dr. Webb's report.
Okay. Is that correct? Dr. Webb still has not turned up a report?
That's correct, Your Honor.
I thought I was told July 22nd his report would be complete, and then I did an order for a week after that. And here we sit a month later, and we don't have a report.
Correct, Your Honor. He's still evaluating her. In fact, I think he went, was it last week? Yeah, he was evaluating her and adding information and making sure that his report is correct.
Okay, in the defense's defense, keep in mind that this is 90 days. This hearing was 90 days from the date that Carly was indicted by the grand jury. The murder was on March 19th of 2024. She was indicted by the grand jury on May 22nd of 2024. This hearing is on August 19th of 2024. So this is rapid speed for a capital murder case. Not to mention the complications that she's a minor being tried as an adult with an insanity defense. That is rapid speed in the defense of the defense. We watched some pretrial shenanigans in Massachusetts regarding the death of a Boston police officer, where the prosecution had not turned over basic discovery for more than 2 years. So in the defense's defense, it's only been 90 days since the indictment.
And as soon as we get it, we were hoping to have it by the end of this week.
Was Dr. Webb informed of the court's order? I entered an order. He was supposed to turn it over. As I recall, defense counsel offered up early July, and then early July came July 22nd. And then I gave an extra week after that. So why don't?
You're right, he's not finished with his evaluation. As soon as he gets done with his evaluation.
When do you anticipate the evaluation being finished?
I'm sorry, what?
When?
We are planning to have it turned in by the end of this week. That's what, and we've informed council offices that that's what we're shooting for right now. But I can't turn it over until we get it. I can't give you right now address.
I'm not putting Dr. Webb driving this bus.
I'm not letting Dr. Webb drive this bus. Okay, Judge. Okay, Judge Dewey Arthur.
County court, this order from this court, there was this court. And that was based on dates that defense turned over. He was hired in April.
Reminds me of the old days when the TV used to like go out of whack, in the middle of the night, and then you would have to like smack the side of your TV because, kids back in the day, TVs were about 24 inches deep, and you'd smack the side of your TV, and then sometimes it would come back to life, or you would adjust the rabbit ear antennas on the top of your TV to get it to come in clearer. That's coverage is about as good as that. It's about as good as 1975.
Whether or not Dr. Jason Pickett can evaluate the defendant. Court's going to grant that order. However, there are parts of that order, for example, it says the defense is to turn over discovery. The state has its discovery, the defense has to turn over their discovery. Do you have your proposed order?
No, sir, Your Honor, and I'll tell you why. The motion that we use tracks the language when we have somebody from the state hospital evaluating the defendant. There was some discussion about whether or not we could get Dr. Giuliano's report and whether that would be redacted and who that would be sent to. So I wanted clarification from the court about whether Dr. Pickett would provide his report directly to the clerk pursuant to Rule 12, or whether that report would be provided to my office to be turned over to the defendant. And so I have not prepared an order yet.
I mean, this judge seems all about fair trial, so I don't know why he's lightning speeding this.
This is going to be the court's ruling. The court's going to allow the state to submit this to Dr. Jason Pickett. Turn over a copy of the order for the close of business today. Any and all related motions, exhibits, and materials must be turned over by the state to Dr. Pickett by the close of business tomorrow. I don't know why we need a completed patient information form. I don't believe that's necessarily required. Information related to the alleged crimes, discovery materials are to be turned over by both sides, both the state and the defense, before the close of business tomorrow. A copy of the defendant's prior local arrest record and NCIC or FBI identification report, any of that would be under control of the state. The state's going to turn that over by tomorrow. Information concerning the defendant's mental health and medical history, including a copy of the report, following a psychiatric psychological expert, providing any previous forensic opinion or evaluation of the defendant. Both sides can turn that over by the close of business tomorrow. All relevant medical, psychiatric, psychological records, and all relevant educational and court, including youth court and employment records, will be turned over by both sides by the close of business tomorrow. Both sides could file a certificate of compliance by the close of business tomorrow. However, I'm forewarning the state, I'm trying this case this time. So Dr. Pickett better be ready to try the case.
I'm warning the case. I'm warning the state. I am trying this case in September. So your doctor better be ready, state.
As to the medical report from Dr. Webb, this court has serious concerns. I cannot for the life of me understand how Dr. Giuliano is able to go interview and turn over the report within a couple of weeks, but Dr. Webb's not. I really, Dr. Webb is not going to be driving the bus. If she doesn't turn over, if you don't turn over the report by the close of business tomorrow, this court's going to look at exclusion.
Your Honor, just for the record, and the rules speak that we have till the 30th of August to turn that over. It's also, we have till the 30th of August to, actually it's 10 days after that. But it says that we have to, that's when we have to file our notice as far as insanity. That's what is the determining factors, whether or not we are using the insanity defense. We have not done that yet. We are still within our time frame to do that. Once we file our notice of insanity, if we do that, Your Honor, then what happens is that sets some things in motion with things out there provide
You need the rabbit ears.
any information that
Tinfoil.
was relied on has to be provided to the state. And that's what the rules say.
That's not what the rule says. The rule says in any event, not less than. However, the willful holding on to discovery material and not turning it over in order to obtain a tactical advantage falls under Taylor versus Illinois from the U.S. Supreme Court.
And Your Honor,
And it says very clearly that exclusion is appropriate in those circumstances. This court finds it very circumspect that Dr. Webb is not able to turn over a report. Has defense counsel turned over the records you intend to rely on in the trial?
Most of the records, Your Honor, have come from the state. And I think
So what's the holdup for Dr. Webb? You gave everything over to Dr. Webb you intended to rely on. Why are we here 4 months later? You're telling me, well, Dr. Webb will get to it when he gets to it. The rule does not say you can hold your discovery until 10 days before. You have to read Rule 12 and Rule 17 to get it. Rule 12 requires a prompt disclosure. And I'm forewarning the defense, this is beginning to sound like a willful attempt to obtain a tactical advantage as outlined in Double Backwith versus State and Taylor versus Illinois.
And Your Honor, all I can tell you is that he is still evaluating her as late as last week. And so when he...
Is Dr. Webb here today?
No.
Oh, he's like, I'll call him up on the stand right now. Is he here today?
Yes, Your Honor, but he knew we were not objecting to her competency to stand trial. And that there would be a stipulation.
He's only testifying about the McDonald issue.
Well, look, you're going to be able to preserve your argument for appeal, but the rule does not say that you can hold on and wait to preserve the expert opinion until you want to. That's not what the rule says. The rule doesn't say you can wait for 10 days before. You noticed this court in July that you were going to be obtaining a medical expert. It is total ambush, a complete bushwhacking to hold the report till 10 days before. And that is not the purpose of an insanity defense. Mental health, insanity defense is a shield for Ms. Gregg. But at the point she tries to turn it to a tactical advantage, she loses that shield. And the state of Mississippi can raise that with the jury. And if...
What do I say all the time? You can't use it as a shield on a sword. That's what he's saying here.
You're going to be trying this case in front of a bunch of people that went to vacation Bible school. This little light of mine, I'm going to let shine, hide it under a bushel nut.
What? A bunch of people that went to vacation Bible school? Is that what he just said? Is he quoting the Bible? Wait, hold on a second. We don't hear this too often up here in the north.
Bible school. This little...
Hold on.
You're going to be trying this case in front of a bunch of people that went to vacation Bible school. This little light of mine, I'm going to let shine, hide it under a bushel nut. Why would we hide this under a bushel? Why would you wait till 10 days before trial?
This little light of mine has just entered the chat.
Truly was insane, or truly was under the influence of these drugs. Why hold it till 10 days before trial? It looks bad from a jury.
Yeah, we're not withholding it intentionally 10 days before trial. First of all, the rules specifically speak when we have to file our insanity notice of insanity defense. We have not done that yet. The case law is very clear that putting the court on notice that we are getting an expert to look at insanity is not putting the court on notice that we are offered insanity defense. We have until the 30th of this month per the court's order, because that's when the motions have to be filed by the 30th of this month. On that day, we have to have done notice. We're getting it done early, and we're working on it. We don't have a report. Dr. Webb is being very thorough in what he's doing because this is a very important case with very complicated issues. And so as soon as we get it, we are going to provide it to the state. So we are not hiding anything.
What have you turned over to the state?
We turned over everything anything that we have had that they don't, we have given them.
Okay. What's the state receive from the defense?
Absolutely nothing. Not one piece of paper, not one name, not a phone number. That's why we filed a motion to compel compliance with rules, criminal procedure 17, back in July, asking for discovery. We've sent multiple emails. We've asked multiple times. We've asked in person. We've been provided absolutely nothing.
Response.
Your Honor, we provided counseling records that we received that the state did not have. We provided those. I'm sorry, Your Honor.
What date did you provide those?
No spoilers in the chat. We're going to look at the plea hearing after this. Please. Thank you. No, her trial's not going on live now. This is pre-trial prep. It is scheduled to start on the 16th of September, and there's a hearing on the 12th next Tuesday. We're getting all the pre-trial done now.
Off the top of my
What
head.
proof do you have that you provided them?
Well, I mean, I have emails.
Do you have those?
If I can find my phone. And I believe we also provided those same records to the state's experts, but everything else has been what we've received from the state.
That's not entirely correct, because in the report that Dr. Gugliano did have, I noticed there was a statement from the stepfather that it's the first time that's ever been testified to before, unless you can show me somewhere in the discovery that it was. I've not seen the discovery, but I heard the man testify, I read the transcript, and I sat down with the report, and there's new information in there that's nowhere in the testimony that does contradict what was stated on the record. So how long did you know about this statement about her mental status in the days before?
Your Honor, I believe we've talked about that since April, on the record in county court.
This is where we are, both sides. The proponent of the evidence bears the burden of showing where you turned it over. Both of them. If you haven't turned it over by the close of business tomorrow, it's not coming. Order to compel is granted, both sides. Your discovery will be turned over by the close of business tomorrow, or it's not coming.
Wow.
If it's not in your custody, that's fine. That's one situation. The court will look at when it came into your custody, but the person offering that proof is going to bear the burden of proving when it came into your custody. Do I make myself clear for the state?
Yes, Your Honor.
For the defense,
Yes, Your Honor.
close of business tomorrow.
Your Honor, I'd like to make an exhibit to this testimony as well, where the state has requested repeatedly for discovery, as well as the emails between myself and Ms. Todd, where she absolutely did not provide those records to me, where I asked repeatedly that they be provided to me, and she said she turned them over to Dr. Gugliano. So it's disingenuous at this time to state that she actually sent those to me.
Objections for the record. Objections for the record by the defense.
Your Honor, I haven't had time to look through these.
Show them to her.
I emailed them to her earlier today. She responded to my email about a plea offer, so I feel certain that she received the email.
I received an email today that I responded to Catherine asking her if the state intended to offer.
But the state is offering emails. Show them to defense counsel.
I just gave her a copy here.
Okay. Objection as to the introduction, as to the court moving into the case.
No objection as to the court.
So we want this to.
This judge is having no shenanigans, Harmony. You're right. Holding them both sides accountable, says Marie. 100%. don't know if she's shackled right now. In the beginning hearings that we watched, she was shackled around the waist and wrists, and when she was in the yellow outfit, but I don't know if she is right now. Thought he said she was not, in addition to allowing her to wear civilian clothing. Now let's move a little bit faster on this.
July 31st. Asking. Else that I'm seeing are July 30th and July 31st, where the state is asking for medical records. What date did the defense turn the records over to Dr. Guglielmo?
Your Honor, if you'll look back, you'll see on Monday, July 22nd, I emailed the records to Dr. Giuliano with Catherine Newman CC'd on that email.
Dr. Guglielmo, did you receive medical records on July 22nd?
I believe so. I don't have the date with me, but that sounds about right. I can show you the email, Your Honor.
You want to make them exhibit?
This was Catherine's exhibit. She gave it to me.
Your Honor, if I may, she copied the email that she sent to Dr. Guglielmo, then sent me an email that says FYI. There were no records attached, which is why I asked no less than 5 times on the 31st to please just send me the records.
Your Honor, may I have them? Right.
Sure.
You'll see. Maybe this is actually where I sent the records and then where I forwarded the email.
She's got receipts as prosecutor.
Here's defense.
In the package, I have an objection based on.
Oh, that's the defense attorney. They're confusing me because they both have long dark hair and they sound similar.
I
Their
have an
voices.
objection based on what she's claiming it to be. So yes, there's an objection to that. It's in the packet, Judge. Nowhere is my email listed in the top of that email where she sent the records.
Objection of the rule, mark it D1.
Mm-hmm.
All right. For the record, you highlighted purple, correct?
Yes, Your Honor. And then the email's below where I forwarded the email.
I'm with you, Gary Raven.
Ms. Todd, that's not what this shows. I mean, it's going to speak for itself. You sent these to forensicspsychservices.ms@gmail.com. You go down, Amanda Guglielmo responds to you, received, thank you. Then you email FYI, thank you, but there's no attachments.
I believe if you get forward, you see where it's attached.
I see where it was attached to Dr. Guglielmo.
Right, yes, Your Honor. If you continue to go, you'll see where Catherine even asked about the dates on the records, and I tell her where the dates are on the records.
All right, I do see. Can you let me know where the records are from and what dates? The Blue Cross Blue Shield printout shows that she saw multiple counts. All right. I will say this from both sides. The purpose of discovery is to obtain a just and fair result.
Imagine that.
This court will not stand for an attorney playing discovery games.
Discovery games.
Close of business tomorrow. Both sides. You either turn it over, if you can prove to me you turn it over, and I'm not talking about an email saying, see, there's some records attached. There will be something to the effect of, we've bait stamped documents 1 through 200, here they are. If they're not in the discovery tomorrow, they're not going to come in unless they are not in your possession. The purpose of discovery is to reach the truth. It is not to ambush either side. Now, I'm going to be frank. If a young lady was suffering from a mental defect or illness or medication, then she should be set free.
Ah, did you hear that? If she is suffering from a mental defect or disease or medication, then she should be set free. This is why he's pushing it. This is why he's pushing it, because maybe he doesn't think she belongs there and he wants to get her out of solitary confinement. Let's hear that again. Imagine if Karen Reed was tried by Judge Dewey K. Arthur. How different that trial would have been. We're going to hear that again.
Of discovery is to reach the truth.
The
It is
truth.
not to ambush either side. Now, I'm going to be frank. If the young lady was suffering from a mental defect or illness or medication, then she should be set free. But if she's not, period, that is a perilous argument. The jury's going to make this decision. Holding discovery does not help anybody. It does not instill trust from the public that a truthful justice is reached. And this court's going to make sure both sides get a fair trial. Only way I know to be fair at this point, y'all turn over your discovery. Close the business tomorrow to both sides, or it's not coming in. It's just that simple.
You said that, Mozzie. You did. I heard
Any more
you.
motions by the state?
Yes, sir, Your Honor. I believe that handled both our motion to compel the compliance with your rule about the mental evaluation order as well as the general motion to compel.
Any motions by the defense that I've not handled that are pending or noticed for today?
No, nothing's noticed for today.
Has the state of Mississippi made a plea recommendation in this case?
Yes, sir, Your Honor.
Do you intend on making a plea recommendation?
Possibly, Your Honor.
Would it be a good day to do it?
Yes, sir, Your Honor. We received the report on Friday afternoon. There were brief discussions between our office and Mr. Camp, and that's as far as that has gone.
If you got to this Thursday to reach a plea agreement, if you want to reach one, if the defendant wants a term of years, then we have till this Thursday to reach that. Otherwise, it's an open plea to some offense. Negotiations are going to wrap up this week. I caution both sides to be very careful not engaging in plea negotiations. Now, I read the mental evaluation from Dr. Gugliano, and I understand the defendant may not be interested in plea negotiations.
This is interesting. Tracy V says the judge's election campaign stressed the need for a pilot mental health court for nonviolent offenders. Anonymous Canadian girl says it's a fair warning. If she's struggling and not responsible, she shouldn't be in jail. But if not, the defense will backfire. There's about a minute left in this hearing, and then we're going to go to the plea hearing after this.
This only goes a couple of ways. If a jury finds that she's guilty and fixes the punishment, life is life. If they can't fix the punishment, I have to decide. It's a minimum of 20 to 40 years. If the jury finds her not guilty by reason of insanity, she goes to Whitfield for some indeterminate period of time. Could be a week, could be 10 years, don't know.
Wow.
But come this Thursday, Ms. Gregg needs to understand it's out of her control. The state needs to understand you're not coming to me after the deadline and saying, well, we'd like to plead her 25, 30 years. Well, I'm not doing that. This Thursday, 5 o'clock, she's either going to enter a pretrial conference checklist or a guilty plea petition. I don't care which it is. Is that clear?
Yes, sir, Your Honor.
Is that clear to the defense?
It is, Your
All right. Do we have anything further? Last time on the state.
Nothing from the state, Your Honor.
On defense.
Nothing.
All right. We'll be in recess.
Andrea Collins, I'll allow it. Andrea says, permission to call him Judge Daddy, Melanie. I'll allow it. I'll allow it. And that is how it's done in Rankin County, Mississippi. Let us take a look now, since we are here. And we are getting very far through this pretrial. I've learned a lot today about this case. How about you? And I'm still on the fence here. I'm still on the fence. I just really do not know what to think, which is, I guess, the way it should be in many, many cases. But there are so many things here at play that it's really hard to wrap my brain around as a mother of 5. And here's the plea deal hearing 9 days ago in front of the same judge, of course, Judge Dewey K. Arthur, Rankin County, Mississippi. Maybe we won't have to bang on the side of the TV or adjust the rabbit ears or tinfoil for this one. Let's see. Oh, we're even going to get closed captions? What? Different Catholic school uniform today.
That is now in session. The Honorable Dewey Arthur presiding. All right, please be seated.
Let's see. Okay. All right, State of Mississippi versus Carly Gregg, cause number 2024-34169. Please bring the defendant to the podium.
She is not shackled, and she's coming to the podium to talk to the judge. So we're going to hear her speak. We're going to hear her speak. This is the only time I've ever heard her speak. If any of you have heard her speak in a different hearing, let me know and send it to me so we can look at it. But here we go. She's going to address the judge, and he's going to question her about this plea deal. Remember, she has just turned 15 years old. This hearing was 9 days ago, August 28th of 2024, and the murder occurred in March, 5 months post-crime. This case is going to trial September 16th, come hell or high water.
By way of pre-trial conference checklist, which means that the defendant has rejected any recommendation from the state. For the record, what was the last recommendation of the state of Mississippi?
Here, the state recommended 40 years in the custody of Mississippi Department of Corrections and agreed to not cross counts 2 and 3 of the indictment. But again, there were fines and no contact and things like that.
All right, Ms. Gregg, did you receive that recommendation of 40 years?
Yes, sir.
And it was your choice and your choice alone to reject that recommendation?
Yes, Your Honor.
You know, if she proceeds to trial, count 1, what's the potential sentence?
Life.
If the jury fails to affix the sentence at life, what's the sentencing range?
20 years to 40 years.
All right, and count 2, what's the potential sentence?
Between 20 years and life.
All right. She's 14 years old, so if the jury fails to affix the punishment at life, she's facing 50 years.
Give or take, Your Honor, yes.
Okay. And in count 3, what is she facing?
Another 10 years.
Another 10 years. So the jury will either acquit you, or you'll be facing 2 life sentences, or this court can sentence you up to 93 years. Do you understand that?
Yes, Your Honor.
It's your choice and your choice alone to proceed to trial.
Yes, Your Honor.
Have a seat.
How can a 15-year-old child make that decision? It's your choice and your choice alone to reject the 40-year plea deal and take this case to trial. I am so conflicted here. I mean, I understand that she has attorneys. She has attorneys representing her and explaining things to her, but she's 15 years old. She's a baby. She's being tried as an adult. But again, 40 years when you're 15 is a life sentence. She'll get out when she's maybe 55. It's heartbreaking. This is heartbreaking no matter which way you look at it. I don't think that there's a lot of different opinions in the chat. I just don't know where I am on this yet. I just don't know. I see the mental health crisis in this country among young teens, and it breaks my heart. I hear her voice. She sounds like a baby. She looks like a baby. I understand that they're dressing her in Catholic school uniforms. She doesn't even go to Catholic school. We don't know why she killed her. But we do know that she did say when she arrived to jail to one of the people who worked in the jail, oh, you know, you can just kill somebody and get out if you pay a lot of money. Something is off.
It says discovery is complete except expert reports from McNaughton experts. I thought I've ordered those to be turned over 3 times. Has that been received by the state?
No, sir, Your Honor. And I just, before you walked in, got with counsel opposite and showed them 2 orders that were motions that he granted last time we were in front of you. The order granting our motion to compel their compliance with the mental evaluation analysis, and also the order granting the motion to compel compliance with Rule 17. May I vote?
The gun was in her mother's room. Yeah, I see. Crow Red Eye. She's charged with an adult patrolling.
Experts at this trial?
Here, we have an expert that's going to be doing an evaluation. We do not plan on contacting him.
All right. Well,
and Your Honor, just for the clarification, we're aware of the time constraints, and we know that we have to get our evaluation done. Our evaluations happen on Thursday. And
actually, the reports were due a month ago, Mr. King. I signed an order more than a month ago.
Yeah, we watched that hearing a minute ago.
There's nothing in front of me to rule on at this time. There's nothing in front of me to rule on at this time. All right. Says that there's some pending motions, anticipated motions, suppress urine test, and both sides think it'd be 3 days for trial. Is that correct by the state?
Your Honor, I believe it'll take probably a little more than 3 days. But there are additional motions that the state intends to file, certainly some motions in limine.
All right. Other defense?
Your Honor, I expect the trial itself to probably take 4 to 5 days.
All right.
Only a 4 to 5 day trial in a capital murder case. Just to remind you, we watched 9 weeks of testimony in the Karen Reed trial. They're trying this case in 4 to 5 days.
I'll remind both sides, these jurors are getting paid a whopping $25 a day. So y'all drag this case out at your own peril.
Oh my God. The jurors are getting paid a whopping $25 a day. So you all drag this case out at your own peril.
However, I'm going to give each side plenty of time to try your case. All right. All motions under Rule 16.1, the motion filing deadline is this Friday, August 30th, 2024. Under Rule 34.1, the Mississippi Rules of Criminal Procedure, all motions must be in writing and must contain a concise statement of the precise relief requested and must state the specific factual grounds and specific legal authority. Failure to comply will result in the motion being considered procedurally abandoned or waived. Responses must be filed in writing before the close of business Wednesday, September 4th, 2024, or the motion may be considered confessed. Reply to any response may be filed if desired before the close of business on Friday, September 6th, 2024. Under Rule 34.2, you must be in court on Tuesday, September 10th, 2024 at 9 o'clock for hearings on pretrial motions. All jury instructions must be pre-filed before the close of business on Friday, September 13th, 2024. This court will not entertain a request for jury instructions either party failed to pre-file unless there is good cause shown. Additionally, an editable copy of all instructions must be emailed in Microsoft Word format to sbutler@rankincounty.org. All right, I need this attorney for the state. I've already signed off on this.
Yes, sir.
Oh my God, yeah.
Do I need to put additional motions?
No, as long as the motions are filed by the motion filing deadline, the court's going to consider all motions both parties file. As long as they contain a legal basis and, some case law. All right, anything further from the state?
All right, I think the only pending matter, and this may be something that we address at the pretrial conference, is the defendant, and I don't have it in front of me, I think filed a motion to transfer to youth court that we've never heard.
You want to hear that on pretrial conference day, or do you want to hear it today?
Pretrial conference day.
All right.
That's going to be Tuesday, September 10th. We're going to be here for it. Motion to transfer to juvenile court in addition to other pretrial motions. I'll see if I can get a hold of them ahead of time so we can maybe look at the motion papers before the hearing on Tuesday so we can talk about them more intelligently and listen to the arguments more intelligently.
The court will hear that matter on pretrial conference day. Anything further from the defense?
No, Your Honor.
Best of luck to both sides. The defendant will remain in custody to await trial.
Best of luck to both sides. Defendant will remain in custody. So I'm liking this judge. I think I'm seeing some really good arguments from both sides of the chat here. T. McCarthy, thanks for the 20. Says, I agree. My instincts are screaming. I'm not in the business of victim blaming, yet the entire thing feels odd and bizarre. I'm terrified what we're going to find out at trial. As a mother, I feel sick. I know I can't put my finger on it either, Jay. Thank you for the 20. Team Brittany says, do you think anything actually triggered this event? I'm so torn about the why of this. Me too. Me too. I mean, some people are born evil, I guess, right? And other people are victims of trauma that can trigger something like this. And so I'm having such a hard time understanding. There was one thing that I did want to show you because there was an opinion from a talking head, and he did explain some of the reasons why this could be happening. I just have to find it because of what was it called? Oh, that's not it. All right, let me see. Yeah, here we go. Court TV had a forensic psychologist on who talked about it a little bit. Hold on. All right. And he's going to give us some explanation for perhaps what the why could be of this, because I think so many of us, and me anyway, I'm having such a hard time wrapping our brains around it. And this just aired 10 days ago, but I liked what this forensic psychologist had to say. So let's take a listen.
In here, that's the other thing everybody wants to know. We know you haven't personally evaluated Carly Gregg, but what do you think might be going on with her?
It's one of those things that the defense actually did have an expert, and I'd be super excited to see what that report ends up looking like. But it's important to understand that there's no mental disorder that would lead someone to engage in an act of violence the way that she did. Now, there could be an argument could be made about the medication that was changed, and yes, there has been suicidality associated with teenagers and using antidepressants, but it's not homicidality, and we don't even associated with teenagers and using antidepressants, but it's not homicidality. And we don't even know what the underlying condition was. Was it depression? Was it some kind of schizophrenia? All of those things would be super rare in someone that's 14 years old to be experiencing them so intensely that they need medication. It's also possible that she's being over-medicated. There's so much more that we need to learn about her mental health that could have contributed in an ancillary way to her committing this act, but still, she chose to do this. You didn't accidentally shoot a gun off.
Exactly, Dr. John. I've got a clip from one of the pretrial hearings where investigators talking about the medication changing for Carly Gregg.
He's a forensic.
I believe she had been taking Lexapro.
And do you know how long she'd been taking Lexapro for?
It was, to my understanding, she had changed it at the end of the week beforehand, but not sure the exact date.
The end of the week before the incident?
Yes, in the prior week, yes, ma'am.
Okay, Dr. John, could the medication change be enough to then have a murder happen?
No, not even a little bit. I mean, it doesn't. Now, you put any psychiatrist on there, and if they say that it did, then they're probably just kind of like a hired gun for this, because the time she would still have a therapeutic dose, even if she changed her medication, she would still have a therapeutic dose inside her bloodstream. So if it's just a week and she changes to something else, then no, that's not possible. These kinds of thoughts and desires and wants have been happening for a long period of time. It was just now she lost her ability to actually stop herself from doing it.
I appreciate that, Dr. John. Back to Carly Gregg's appearance. I can remember that first day when she was in court for her arraignment. I'm sure you both can remember the image too, because it was circulated. She's sitting in the jury box, because sometimes judges will have defendants go in the jury box before they're ready to be called if court isn't quite in session yet, or they're waiting for their case. And she's sitting there, and there are a bunch of older men, charged with whatever, and they're looking at her like, I'm sure, like, child, do you belong in here? I mean, you look so young, and like, what did you do? I'm sure nobody's thinking, she might be the only one in the jury box who did a homicide. Susan, tell me.
All right. I know I'm not a huge fan of hers either, but I am sorry, because that is not the proper psychologist that I wanted to show you. It's this one from 3 months ago. And I think that he had a more interesting take than that doctor did. So I try and cut Julie out of this, and I'm just going to let this expert speak to you for a minute about her mental health, his opinion on her mental health.
Dr. Dom Sportelli. Good morning, Dr. Dom. Nice to see you. What a dreadful case to have you on talking about, but we really want to tap into your expertise with children. And let's start, if we can, please, with your initial thoughts when you hear the facts as we know them.
Oh, Julie, well, thank you for having me on. And I have to say, horrific, tragic, shocking. As a psychiatrist and a behavioral health expert, and as a parent, when you hear these stories, it's just absolutely shocking. Now, I want to talk to you a little bit about the statistics of this. Now, the name of this is called parricide. Parricide means homicide towards a parent. It's actually pretty rare, Julie. It's about 1% of all homicides. Now, interestingly, out of that 1%, it's mostly adults that commit homicide toward their parents. These are individuals over 18. Now, when you take people under 17, now juveniles, you're talking of only 16% of that 1%. So it makes it even more rare. So this is a very rare phenomenon. 82%. Yeah, sure.
Oh, no, please. No, go ahead. I want you to finish. And then
just let him narrate. Let Robert tell us, please.
You said.
Of course. And just for more statistics, just to really understand this and to put it into perspective, 82% of them actually act alone. It's usually a very independent crime. Now, we do have some thoughts, and there's been a lot of research as to why children might be motivated to do this, and we'll certainly get into that.
Right. And that's, I think, one of the most stunning things, the motive, what could have been going on, and were her thoughts being altered? The change in medication is something we are very curious about, and we don't know what she was prescribed initially. We just know that the change was about 1 week prior to the shooting, and the change was to Lexapro. And we know that she was singing after.
There's so much going on here that I think we really have to look at big picture first. And most psychologists and psychiatrists and forensic psychiatrists completely understand that, as rare as this is, there are 3 basic categories that we can put this into. We tend to see that there are 3 motivating factors, and of course there are outliers. But Julie, what we see the most is this. Number 1, we see severely abused children that engage in these acts. Now, these are kids, it makes sense. They're trying to end the abuse. They've tried to run away. They've even tried to commit suicide. They're trying to protect themselves. They're trying to protect their siblings, perhaps, and they engage in this homicidal behavior toward their parents. That's number 1. Number 2, which I'm sort of leaning towards here, is what we call the dangerously antisocial child. And being in forensics and law, I'm sure that you completely understand sociopathy and psychopathy. These are individuals that they have a persistent lack of empathy. They just don't feel remorse. They're just so detached. Now, in this category, the dangerously antisocial child, the motivation is, as crazy as it sounds, is to further the child's own goals. They look at the parent as an obstacle. Maybe the parent doesn't want them dating somebody. Maybe the parent is not letting them go out at night. Who knows? But we do see a pattern of defiance in these children. We see a pattern of minimal responsibility for their actions, sometimes violence towards animals and other people. Now, that's number 2. Now, number 3, just want to get through these. The third one, too. Now, this also kind of fits This is the severely mentally ill child. This is number 3. And this could potentially be a diagnosis of what we call psychosis, which is a breach in reality. The child sometimes hears voices. Sometimes they hear command hallucinations, like they hear God telling them to do things. This is much more rare. But the statistics, Julie, on the mentally ill child that kill parents are usually older. They're usually young adults over 18. In this case, it really, really looks like the antisocial picture to me. But I do want to get to the SSRI, the medication question as well.
Right. No, appreciate it, Dr. Dom. And
So
that
there's his take in a nutshell, kind of, a little bit. And that's what I just kind of wanted you to hear. You know, kids that are severely abused is one category, kids who are defiant is another, and kids who are severely mentally ill or psychotic. And I think there's just so much more to learn about this case, and I'm torn. I see that a lot of you guys have very, very differing opinions of this. CJ's mom said she claimed to friends that she was abused at home, but there's no evidence to support her allegations, and police cleared her stepfather of any wrongdoing. That's the first that I'm hearing of this, so that's really interesting to me, CJ's mom. If you have any citation of that, I would love for you to email it to me. If one of my mods could drop the email in the chat, that would be amazing. Happy birthday again to Scott. Team Brittany said, I kept Scott's secret as long as I could, but when he talked bad about my girl Taylor Swift, I had to expose him. Love you, Scott. And look what you made me do. I showed the clip last night. If you weren't here, Team Brittany, last night of Taylor walking into the Chiefs game because Mark Betterow and I scheduled a show during the football game unknowingly, unwittingly. And so I thought, I wanted to make sure nobody missed anything. So I showed her entrance. She had thigh-high red boots on. Did you see it? The drunk driving Higgins, Yana, he has been put over. He's going to stay in prison. This is with regard to Johnny Goudreau and his brother Matthew. He's going to remain in jail for at least another week, awaiting a pretrial hearing. So it hasn't happened yet until at least Friday the 13th. So thank you for reminding me. So he's going to remain there until at least Friday the 13th. So we will cover it then. Thank you so much for that. Pilgrim Shadow, again, on that same vein, said, did you see the drunk Higgins dude who slaughtered the Goudreau brothers? Gets to sit in jail for another week. Yeah, I just did see that. Well, my friends, that is where we stand for today. Thank you for joining me on our pretrial journey of the Carly Gregg trial, which is coming up very shortly on the 16th. We will be back for the pretrial motions hearing next Tuesday. Please hit the like button, and thank you to the mods and all of my amazing moderators who keep this chat so classy on the regular. And I have to, Harmony, listen to Who's Afraid of Little of Me an obsessive amount of times. We have a house full of Swifties here. These are tough topics to cover, but we're going to cover them because they need to be talked about more. I mean, as far as I'm concerned, Sarah Boone case is like, it's just not interesting to me. It's just, this is far more interesting to me. I want to know why this happens. I want to know what causes things like this to happen. I want to know why young teenagers are killing people all over our country and the world and their parents, and it horrifies me. So we're going to talk about it. Make sure you subscribe and hit the bell so you'll know when I go live. Notifications on YouTube are really weird lately, and they're not really working for some reason. I don't know why. I don't know how to fix it. I don't know what to do about it. But please hit the like on your way out. It really helps the video. It helps the channel. It helps it get pushed out there. Feel free to share and like the video, and replay viewers, channel members. I love you so much. So we need to do a members only soon. Thank you so very much. And as I say to end every stream, look, just be cool, be kind, be classy. It's not hard. It's really so not hard. It'll make your life much happier. I promise you. Peace, everyone. I'll see you real soon.